Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. My name is Amy Blake. Today, I am joined by, to my right, Justice Maureen Walsh, and to my left, Justice Christopher Hodgins. We are your panel for the 6 cases that we will be hearing today. I know most of you have been here before, but just to briefly go over the rules, each party is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read everything, so you should get right to your arguments. We will likely be taking a break after the 3rd case. With that said, I will call our first case of the morning, Commonwealth versus William Wright, docket number 23P1296. Good morning, Mr. Crane.
Good morning. May it please the Court, Edward Crane on behalf of William Wright. The combined impact of the Brady violation and the Guardado error in this case was not harmless beyond a reasonable doubt. As a result of the Brady violation, the defendant was deprived of crime scene photos that he could have used to attack the credibility of the officer who testified that a licensing check was done.
So I feel like you and I have done this before.
We have been here.
Okay, so I have a question for you. I think it's roughly around page 33 of your brief. I want to just get right to the credibility issue. You make the argument about the boots and the photo, and I get that argument. But you make an argument about booking. And I honestly can't understand how the photos change. It seemed like it was Monday morning quarterbacking about the booking argument. That could have been made with or without the photos at the time of the original trial, no?
There are aspects, yes, the argument that the officer testified at the motion hearing inconsistently with how he testified at trial with respect to his involvement in booking, that's something that wouldn't have involved the photos.
So for me, it's more, I don't speak for my panel members, it's really about the boots. And I was on the panel that reversed the other conviction, so I know what we said, and I'm not sure that I agree with Brother Counsel that there is an estoppel argument here because you are interweaving Guardado and Brady. But I guess what I'm having trouble with is, what about the photos changes the evidence about licensure? So let's say he got it wrong about the boots because we have the photo and we have the testimony and they're different. I don't mean to be flip, but so what as it relates to the licensure, particularly where your client under the statute wouldn't have been eligible for a firearm license anyway because he's a felon. And so I'm struggling. Can you help me?
Yes, Your Honor. I think it's sort of a 2-part question. I'll address the first part with respect to how the photos of the boots would have helped. I think that they would have been conclusive proof that the officer's recollection of the investigation was not entirely accurate. I think at that point what the defendant had was some evidence, some insinuations he could have made that the officer did not recall the investigation.
Yeah, but he had already acknowledged that at the trial. He said on page 119, the transcript, he said, I think he had boots on. So he wasn't entirely clear as to how he came into possession of the boots. In other words, you're almost suggesting that the booking officer, unlaced the boots and pulled them off his feet when the photograph shows, oh no, the boots were, back at the scene. How could that be? But he never really said that. He didn't exactly recall how he got custody of the boots. He just said, I logged them in.
Yes, and I think, though, that the photos could have established that certainly that his recollection there was inaccurate with respect to his involvement in booking. And I think that what it comes down to is the officer's recollection as to whether, at the first trial, his recollection as to his involvement with taking the clothing off the defendant, that was an important fact. Clearly, licensing at that point was not an important fact because it wasn't an essential element of the offense. Now, if the officer's recollection of his taking of the clothing from the defendant is something he doesn't recall quite accurately, then I think certainly it could be argued that he doesn't recall accurately whether a licensing check was done or not, that being a less significant aspect certainly of the trial at that point. And then addressing, I think, it's important to return to the point about the defendant being a prohibited person. I think the analysis here, and this I think is somewhat up for debate, but the analysis here with any Brady violation has to be what the defendant could have done. I don't think that we can look at these questions and say, well, the Commonwealth would have done this if not for the Brady violation. I haven't come across any case that says that the analysis in a Brady violation goes that far. It's how could these have impacted the defendant's presentation at trial?
So to that point, I found a case that actually neither of you cited, so I'll give you the site so you can take a look at it afterwards. It's 100 Mass Ave Court 588. It's called Commonwealth versus Diaz. And there's a whole section on prejudice. And to the point you're making, what the appeals court said in that case is, in judging whether the defendant has shown prejudice, we must decide whether there is a reasonable possibility that the non-disclosed evidence would have made a difference. And I think you cite that in some older cases. So I'm really thinking about that sentence. What would the non-disclosed photographs have made a difference in as to whether or not he had a license to carry?
Well, they wouldn't have directly impacted, clearly, the testimony about a records check was done and there was no license issued for the defendant. But what the defendant could have done with those photos is call into question how well this officer actually recalled what happened at the investigation 3 years earlier. Did the officer the defense counsel certainly could have argued that, look, officer, you've had many cases since then. You've run licensing checks in those cases. Are you sure that you remember accurately that the licensing check was done here? I think you could have pressed him more on that. And obviously, again, the photos don't impact, they're not directly related to the licensing check, but being able to call the officer's recollection of the investigation into play.
Can I just interrupt for a moment? If I were to accept your argument, then in almost every case in which there was non-disclosed evidence, and that evidence related to an attack on someone's memory, right, and their credibility, then if I accept your argument, then in every case, no matter how disjointed the issue is, that it would result in finding that it's not harmless beyond a reasonable doubt, right? Because how could you not? I mean, if you're always saying, this is something that has to do, I could have gone back and I could have questioned because he said the shorts were red, but they were really blue. Well, then how do we know he really checked this or that? Then you'd always kind of have the result that you would want. And the standard that Justice Blake just expounded upon, would it have made a difference? It wouldn't. As long as you show that the evidence wasn't turned over, if I accept your analysis, tell me how I'm wrong in thinking you'd always kind of be successful in a claim that this would have made a difference.
Well, I think it's a good point, Your Honor, but I think that there is a line that can be drawn between, say, for instance, there was a case where the undisclosed evidence showed that there was some sort of error that the testifying witness made with respect to a particular point. But the crux of the testifying witnesses, the important part of the testifying witnesses' testimony is not at issue, that the undisclosed evidence doesn't call that into play. I think in those situations, it's a tough argument to say, well, because you didn't remember whether you woke up at 9 o'clock or 8:55 on the day in question, you don't recall whether you saw the defendant shoot the victim. Clearly, there are distinctions between that. Not remembering a minor fact is different from not remembering a hugely essential fact. And I think what we have here is not remembering what I think is a significant thing in the course of the case, or fairly significant in the course of the first trial, which is where the the defendant was, where the clothing was taken off the defendant. And then we have a minor fact, which is whether he had a license or not. At the time, that wasn't an essential element of the offense, so I think that the defendant here could have used the photos to show that you don't recall, this officer does not recall a significant fact, and thus I can call into question whether he involves this even less significant fact from this case.
But if we didn't, but for Guardado, we wouldn't be here, because in the first case, my panel said, Brady violation, these 5 crimes, I think it was 5, are reversed, but the gun stands, and this is why the gun stands. And so Guardado comes, upsets the apple cart across the Commonwealth, right? And rightly so, you bring these motions and this appeal, and I get why you're here. Please understand that. But I'm struggling with, we've said those photos didn't impact the gun charge. Now, I'm not talking about estoppel yet. I'm just saying the gun charge stood notwithstanding our finding, our conclusions about the Brady violation. Why does Guardado change that?
Well, it changes that because it makes it clear that the licensing aspect of this case is an essential element of the offense.
But we have Bookman and the cases after Guardado that say the question and answer to which there was no objection, so it's in for all purposes, it's in for the truth of the matter. Bookman says it's harmless beyond a reasonable doubt.
And I think what distinguishes this case from Bookman is that Brady violation. If not for the Brady violation, I'd probably still be here, but I'd have less to stand on. Clearly, there's a lot still being litigated as to all these Guardado cases.
Absolutely.
And how Bookman impacts them. But I do think that the primary distinction is the Brady violation. But I do think there are other distinguishing points, too, and that the nature of this testimony here was hearsay testimony. The officer's testimony was that someone, it's unclear who, conducted
What's your best case that says, without an objection, I mean, it's in. You might not like that that's the state of the law, but isn't that the state of the law?
And I told myself I wouldn't take the bait on this, but I think I'm going to have to, and just argue. I do believe that Bookman has some logical flaws to it, in that I guess I'll go to Guardado too, in which the court says that we can't hold this against the Commonwealth, that
No, you make that argument in your reply brief, and I understand that argument. Can I ask you a different question?
Thank you for saving me first from
I'm saving you from
going down a
yourself.
tangent arguing that this court should overrule the SJC. I'll stray away from that.
Can we talk about standard of review for a second? On the estoppel argument, and I'm going to ask your brother about this. He says it's prejudicial error. You say it's harmless beyond a reasonable doubt. Which is it?
I think it's harmless beyond a reasonable doubt. I think these are both constitutional errors.
Okay.
And I would say it certainly makes the analysis a lot easier if they're both constitutional errors. Otherwise, we're going to have to conflate standards here. But I do think that the analysis ultimately is, and what this case boils down to, is do the two combined errors here amount to a prejudicial impact that is harmless beyond a reasonable doubt.
Do you think the language in Bookman about, well, I don't want to misquote it, and I'm sure that I will. Do you think the language about the credibility of the officer is dicta? The officer's credibility was not in question. Is that dicta?
I don't think that's dicta. I think that that's an important part of the Bookman decision. It's an unfortunate part of the Bookman decision, but I do think that it is part of it. And clearly, the discussion in Bookman was a small part of the case. It was a first-degree murder case. There was a lot of other issues, and this was sort of a tangential aspect of the Bookman case. But again,
Don't want to go too far outside the record. Are the other cases being retried?
yes,
And that has not happened?
that has not happened yet. No. The court has no further questions. I'd rest on my brief.
I don't see any. Thank you, Mr. Crane.
Thank you.
Mr. Wendell.
Good morning.
Good
May it
morning.
please the court, ADA John Wendell for the Commonwealth.
Can we start with estoppel, because I'd like to maybe get rid of that.
Okay,
Isn't there an exception when there's a new case law, and Guardado is new case law?
the problem, Your Honor, is that this idea of combining the two errors, there's no case law to support that argument.
Oh, that's Mr. Crane's special, though. That's why he's here.
But-
We have a Brady violation, we have Guardado, we haven't had a fact pattern like this one.
Well, but we have had many fact patterns. When there are multiple errors are considered each individually. We don't consider the Brady issue and the Guardado issue in combination. The Guardado issue is a jury instruction issue. There's a jury instruction error. We consider that error in isolation from any other errors. And then we consider the Brady violation in isolation from any other errors.
Oh, I don't know.
This idea that we combine them, we only combine things in the cases of the unique confluence of factors cases, which this has not been argued to be one, which that takes us back to the standard of review that the judge cannot have abused his discretion for failing to consider an argument that was not made to him. And the cumulative effect of multiple closing argument errors, those are really the only two times that multiple errors are considered in combination.
Well, this is just it's so interesting, right? Because we said in round one of this case that these 5 charges are out and the firearms stand.
Yes.
And then Guardado gets decided and then Mr. Crane's back. And I understand why he's back. What I'm trying to figure out, though, is I'm struggling with the estoppel argument. I don't want to spend a lot of time on it because even if we assumed without deciding that estoppel didn't apply, the merits here, I think, we need to spend a little bit more time on. But I'm struggling with an estoppel argument when we have new SJC case law.
Well, the basic argument made in the original, or well, the second motion for new trial was, I was prejudiced by the non-disclosure of these photographs because I could have used them to challenge Detective Dion's credibility.
Right.
That is the exact same argument that is being made here. I was prejudiced because I could have used them to challenge Detective Dion's
But
credibility.
in this round, it's as to whether or not he properly recalled checking to see if Wright had a license to carry.
And part of the problem we get...
He says, I didn't know to ask that because that wasn't the law in round one.
Well, and that's part of the problem, is that that wasn't the law in round one. Nobody knew to do any of this because this case was tried in 2016. We're only here because it took a very long time to litigate through the motions for a new trial, partially because of COVID.
Right.
The delays in this case, it's at some point we have to draw a line and say, you've made that argument before, and this argument based on a new case, he made that argument before in the exact same way. He's just saying, well, but it's a different element. But so what? He made that argument before in the exact same way.
All right, so humor me for a minute. Let's get to the merits, if we could. How does Wright being a prohibited person impact this argument, if at all?
Well, the problem, part of the issue here, Guardado, as a constitutional trial error that is non-structural, it's reviewed under the harmless beyond a reasonable doubt standard based on the trial record as it was. A Brady violation is not a trial violation. It's actually a pretrial violation in many respects. So you consider Brady violation in terms of what could have been if, but you consider a Guardado error in terms of what the record was. So what could have been if he had known to challenge Detective Dion's credibility because firearm licensure was an element of the offense at the time, then the Commonwealth would have known to present evidence of the defendant's lack of license far beyond a simple question with an answer that is technically hearsay, though in for its truth because of the lack of objection. We could have presented the evidence of his status as a prohibited person. There was a statement in his interview admitting to being a prohibited person who has a gun record, and I quote, "a mile long." So if we had the problem in the original Brady violation. Part of the reason that this court reversed was that there was no joint venture instruction, which my argument for lack of prejudice had been, well, we could have asked for a joint venture instruction. The response is, well, you didn't. But here, we're getting so deep into the hypothetical what I could have done if, that it's not a simple matter of, well, you didn't do that, because we did present evidence of lack of license. So it's fundamentally different than the original go-around. We did present the evidence that the defendant now says, oh, I could have done this thing. We presented evidence to counter that. I could have challenged the conviction on the basis of lack of license. We presented evidence of lack of license. So,
You know, this case, it just strikes me as a great illustration of the disconnect between the reality of the trial court and what happens in an appellate court, because as you're talking, it's becoming very clear to me that, you know, I'm sitting here wondering why in the world would a defendant in the trial court want evidence of the fact that he's licensed to carry a firearm when his whole defense is, I wasn't the one wielding the firearm, that it was the other guy.
right. That is actually a fascinating perspective on this. I haven't thought about that much, but I suppose one of the oddities of this case, if the Commonwealth had requested a joint venture instruction, we probably wouldn't be here because the other 5 convictions probably would not have been reversed. And frankly, I don't think this case would have been active at the time that Bruin came out, such that Guardado would apply to it, because the Brady error would have been non-prejudicial and would have been far more clearly non-prejudicial had we asked for the joint venture instruction. And under his admission, he admits to providing a firearm to the other individual. He admits to picking up the firearm, so he does actually admit to handling the firearm. So therefore, he needs a license. However, I see your point, Your Honor.
So of all the cases, and there haven't been a lot, that have addressed Bookman, what fact pattern is yours the closest to?
I would say Bookman itself.
Okay.
Some of the other cases, there's other clear evidence of lack of license. Bookman itself is the most clear that the statement by an officer, I checked and he didn't have a license, if there's no objection and the officer's credibility is not challenged, is harmless beyond a reasonable doubt. And that's what we have here. This case mirrors Bookman almost perfectly, except for the added twist of the Brady violation. But for purposes of the Guardado error, we do not consider the Brady issue because we consider the Guardado error on the trial record as it was. So, if I could just have a minute.
I mean, and again, I'm stretching these hypotheticals, but if I were to accept your argument, then in facts in which the Brady violation resulted in absolute clear photographic pictures that somehow showed that, in this case, Officer Dion didn't do a background check, not questioning his credibility if he remembered whether he did it or not. You're suggesting that when we analyze whether Guardado kind of renders this error harmless beyond a reasonable doubt, that we turn a blind eye, right?
Yes.
And that would be difficult, I would say, because if we had absolute proof, I know we don't in this case, that the Brady violation resulted in proof that the officer didn't do the license check. So in analyzing this error, you're suggesting to us that we don't consider that fact. And I don't think Bookman addresses that issue, because this case involves officer credibility.
I guess I'll answer your question yes and no. If we had that clear evidence that Detective Dion had not personally checked whether he had a license and could say, I could have used this to clearly prove that he did not know that personally, that's fundamentally different from the photographic evidence that we have, and that changes the characteristics of the Brady violation. But the Guardado issue...
But earlier you had said Brady in this corner, Guardado in that
Yes.
corner, and we put up a wall.
Right.
Now you're saying we have to look at the nature of the Brady violation to see if it affects the Guardado.
Not precisely. I
Tell me where I'm
apologize if I was unclear about that. We analyzed the Guardado issue on the trial record as it was. Doesn't matter what additional evidence there was. The Brady violation, the argument is, I could have used this to challenge the officer's credibility. There's a case, Commonwealth versus Ellis. This is 475 Mass 459 from 2016. That was a case involving officer misconduct, and there was a revelation after trial that the officer misconduct had involved specific malfeasance involving the specific victim in the case, whereas the prior evidence, the originally disclosed evidence, was simply that they had engaged in malfeasance in unspecified cases. And the Supreme Judicial Court said in Ellis that the distinction, the factual distinction between malfeasance with this specific victim and malfeasance in general was sufficient to overcome the issue of estoppel. So the argument, I could specifically have disproved that he knew that I didn't have a license, is a different argument than I could have challenged his credibility. The argument we have here is I could have challenged his credibility, which is the argument that was made originally and found to be non-prejudicial. The argument here is, the argument in your hypothetical is, I could have challenged this one specific fundamental fact in this very specific way. So estoppel would not apply and the Brady violation would be prejudicial in that circumstance. For reasons that connect to the Guardado issue, but the Guardado issue is an instructional error. The reason the Brady violation appears to connect to it is that it concerns the element that renders the instruction erroneous, the omission of which is the error. So a significant enough change in facts could lead to non-estoppel on the Brady violation, but for purposes of analysis of the instructional error, we're limited to the trial record itself. I see I'm running short on time, unless there are any further
We
questions.
don't see any other questions.
Right.
We can take
Thank
the
you.
rest of the argument on your brief.
Thank you.
Counsel, this was very well briefed and very well argued, very interesting issue. It is under advisement. Thank you both. Thank you. Perhaps this will be the last Mr. Wright case. The next case can begin getting set up, and that is Commonwealth versus Abdallah Bala, docket 23P 1049. I will remind counsel that this case is partially impounded, so please do not use the names of any victim or witnesses. Good morning.
May I begin?
Absolutely.
Thank you. Good morning. My name is Gabriella Robin for Mr. Abdullah Bala. And this case presents two issues, but I'm going to focus on the first issue, count one.
Mind maybe moving the mic down a school?
Sorry.
No, that's perfect. Thank you.
I always forget I'm shorter than I think. So I'm going to focus on the first issue, the count one, which is the indecent under 14 on Mr. Abdallah's sister, who is AM. which takes place in Claiborne Street. And I say Claiborne Street because I think that's the easiest way to parcel the two events. AM's testimony was equivocal regarding her age at the time of the event, which amounts to equal and inconsistent testimony, so the motion for the required finding of not guilty should have been granted. Now, quoting from Dumas versus Marcelli, which presents almost the exact scenario as this case, quote, "The victim signaled herself had some doubt as to her age at the relevant time. Without more, a rational jury could not disregard this doubt and then conclude beyond a reasonable doubt that she was under." So if we look at the evidence that showed that she was under, when asked by the Commonwealth if she was 13 when this event occurred at Claiborne Street, she testified that she thought she was. She didn't say, yes, I was. She thought she was.
Can I interrupt for a moment?
Of course.
Because that's not the lens necessarily when there's a sufficiency argument that we take a look at. We don't look at the whole and say, oh, at times she was equivocal, at times she is this and that. You would agree that the standard is that we look at the facts in the light most favorable to the Commonwealth with all reasonable inferences, correct?
I do, but I think this presents a different issue because these are two different propositions. This is not a case of credibility, per se. It's not. This is not a situation where one witness says one thing and another witness says another thing. This is the main witness, their main evidence against my client, and she's very equivocal about her age, which is obviously an essential element of count one.
So, again, we can disagree about the inconsistent theories or et cetera, but when it comes to a factual finding of whether the Commonwealth has proven whether a particular element, which is that the alleged victim in this case was of a certain age, you would agree with me that we look at that in the light the testimony in the light most favorable to the Commonwealth, correct?
We do.
And so, tell me why, when I read this record, and there are leading questions that appear to establish that the victim, alleged victim, then adopts the age to qualify that she was 13 at the time.
So this is a different situation because at the same time, while she's adopting that, she's also adopting the fact that she was over 14. So she's adopting two theories, and I would suggest this is not a case of repudiation.
A theory versus a fact. I guess, so theory to me, certainly it's an element the Commonwealth has to prove, but I'm having a difficult time understanding your argument of a theory.
I don't know if it's a theory, it's just she's two different.
You had said that.
Oh, I'm sorry. Maybe I might have said differently. So she's adopting, yes, she's adopting that she's under, she's also adopting that she's over. And I would suggest that this isn't a case of repudiation in which then later the Commonwealth came back and said, well, you would agree that you actually were 13 at the time. And she says, yes, that other information, something to the effect that that other information was wrong. She never did that. And I think that this is exactly like the two cases I cited, the Dumas case and the Traynor case, when they had said that this is not enough to go to the jury. This is conjecture, which cannot go to the jury.
So I would agree with you when there's conjecture and a jury cannot determine that a particular element has been made, then under the lens of the sufficiency, I agree. It's not enough. But in this instance, I guess I'm questioning why this isn't enough. Because just as the Commonwealth has to prove consent, for example, and there could be testimony from which a jury would either find that there was a consensual encounter or an unconsensual, not this case, but I'm just giving it as an example. I don't see how we don't take a look at the trial record and say that was enough.
Because I think, I quoted in Dumas, what's happening is they're saying a rational jury can't disregard the doubt, so it's not enough for the jury then to find her beyond a reasonable doubt, and a required finding should have been imposed. I think this is a different situation where it's like a credibility, as I said before. I really do think these are two different propositions, and this is an element of the charge. And what the jury can't do is decide, you know what she really meant was the first one when she was under. That's why it's precluded from doing that. And as I said before, this isn't a case where she repudiated her fact that she thought she was over. I mean, it was very clear. She was confused about her age. It was very obvious from the transcript.
So when the jury asked the question about the timeline, what did the judge respond?
I believe it was that, they had the evidence before them, and only that evidence.
You point to that question as some evidence. I think you said it in a footnote, though, that the evidence was insufficient. But I read it to say they came back and asked the question, and the judge basically said, you have the evidence, you decide. And to Judge Walsh's point, in the light most favorable to the Commonwealth, they decided based on the evidence and the reasonable inferences that for that particular set of facts, she was under 14.
Yes.
Are you arguing the
Oh, sorry.
doctrine of lenity?
No, I think it's not, it shouldn't have gone before. Sure, that the course of events happened that way because it went to the jury. My argument is that it should have never gone to the jury because of these two different opposing equal but inconsistent propositions, which I think is the crucial argument in this case, that it's not a credibility issue, as the Commonwealth cites in their brief. This is not a situation of a credibility issue.
So are you saying that in one part of her testimony, she testified she was over 14, and in one part she testified she was under 14?
Yes.
And you say that is what? That's not credibility, that's what?
They're two different propositions, is what it is.
And what does that equate to legally?
Illegally, when there's two equal but inconsistent propositions, I'm sorry, hold on one second.
Take your time.
That is not enough, basically, to go for the jury, and because of that...
So that's insufficient evidence.
Thank you, insufficient evidence for them.
Now, where did she testify that she was under 13? Because I was having trouble finding that.
She said that when she was asked by the Commonwealth, she was 13 at of the incident, she said that she thought she was. But then she later testifies that she thought she moved to Claiborne Street in 2016, 2017, and then based on her date of birth, that she could have actually been 12 or 13. But at the flip side, as the court's aware, there were other times when she said that when she moved to Claiborne Street, she was 14 or 15, and that she wasn't even, she also conceded she wasn't even sure when the incident occurred. Then if you go through the numbers, she also said she didn't move to Claiborne Street until 2018, 19, or 20, and that given the fact that she said it was this fall, she could have been 14, 15, 16 based on her age.
Well, that's what I was having trouble with, and I think jurors were having the same trouble, is that she never came right out and said directly, he touched me when I was 13 years old.
I would agree with that. It was very confusing, and you also had to do with, I had to do a little math, and that's, to start figuring out the times.
And in fact, when I forget if it was a male or female, when the prosecutor said, tried to kind of button it up and said, well, when you were around 13, so the prosecutor never even said specifically, when you were 13 years old, even if it was leading, the prosecutor never even did that, right?
I believe the record was sort of similar to that. It wasn't the most clearest, but I do believe at one point he said that you were 13 at the time, and she said, oh, I think so.
Around 13.
Around 13, yes.
But my point still being is that given what our lens is in reviewing a sufficiency argument in the light most favorable to the Commonwealth, if the alleged victim says she was 12 or 13 at one point in time, despite vacillating or not sure or this or that, she says, I'm 12 or 13 when I moved to Claiborne Street, and there's later testimony, she's about 13 when this incident happened. Isn't that enough with
No,
reasonable inferences?
I don't think it's an inference. I don't think there's any inference, and as I said before, it's insufficient evidence. It's one of the elements, as we're all aware, of the charge is that she's under 14. So they're faced with these two different propositions, and the only reason why I comment, when she says she's under, it's not even that it's a very confident. I mean, I think it's more clear that she's just confused about it, and there was actually no other documentary evidence that was provided, which is actually touched upon in Traynor when they actually find for the defendant, saying that this isn't a case where we had school records or anything. It was very equivocal. As the Commonwealth notes in their brief, there is no lesser included crime of indecent under.
I mean, I guess my question is, she could have been younger than 13. So when she testifies that she was 12 or 13 when she moved into Claiborne Street, and then the prosecutor asks a somewhat leading question of, so when you're around 13, did anything happen in that living room? Isn't the jury permitted to infer from those two pieces of evidence and testimony that when she was 12 or 13, around 13, but 12 or 13, and was at Claiborne Street, this sexual assault occurred?
I don't think they're permitted to. I don't think it should have.
Why not? Tell me why not.
I don't think they're permitted to, because at the same time, while they're hearing that, where she's not even very affirmatively saying it, but regardless to that, they're also hearing testimony. So basically, the Commonwealth's testimony is that you were around 13 when this happened, yes, and then later something about moving to Claiborne Street in 2016, 2017. Okay, but then at the same time, she's also very, very uncertain, because then she's also testifying she didn't move to Claiborne Street until she was in 7th or 8th grade and she was 14 or 15. And then also, she's also changing when they moved away, and then they moved away.
I agree with you that there is certainly not the clearest record as exactly how old she is, but the Commonwealth doesn't have to prove exactly how old she is. It's to prove that she was under the age of 14. And so, absolutely, was she on this date when I was 12 years and 3 months, this happened? No. But that's not what has to be proven here.
But what can't happen is, as I said, in the two cases, I mean, you're asking what authority. I'm going to cite the Commonwealth v. Traynor in my brief, and also the Dumas Marcelli is, as I said, when there's some doubt, what they can't do is decide beyond a reasonable doubt and forget about that. So there's insufficient evidence. And I would cite the two cases, which I think are both completely on point, very, very similar, very narrow. I mean, this is obviously, as we know, is a very narrow issue we're doing. So I would suggest that, as I said before, this isn't a case of credibility. It's just not credibility. Credibility would be something else, which you can choose to parcel parts of the information. You can't do that in this, because they're different propositions that are equal, but then also inconsistent. So following that, I just would say in terms of the second argument, if that's okay, will briefly touch on it, that the motions to suppress should have been granted, allowed. He didn't voluntarily waive his Miranda, and his statements weren't voluntary. And if the court doesn't have any other.
I don't see any. Thank you very much.
Okay,
Counsel.
thank you.
Attorney Knight.
Good morning. May it please the court, Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I read the transcript a bit differently. The victim here wasn't equivocal about the age of the event. She was more equivocal about the age she moved. And I think the transcript spells that out. When she was talking about being 14 or 15 when she moved to Claiborne Street, the prosecutor then went back and made sure that she understood what the year was, and they did a little math right in the transcript to show that she was 12 or 13. It goes on to show that she adopted that she was, in fact, around the age of 13 at the time of the event, but that around doesn't necessarily mean above. It could have been 12, as evidenced by the math that the prosecutor
Well, this goes
did.
to my question.
Correct.
Would you say when the prosecutor said that, prosecutor said, this is on page 171 of volume 1. Okay, so when you were around 13 years old, did anything happen in that living room? Yes. And then she goes on with that. Is that the best evidence of her age right there on that page?
I would say best evidence in conjunction with the fact that she put in her birth date, which was August 15th of 2004. She moved to Claiborne Street around 2017. The complaint says 2017 was the time of this incident. And then when she goes on to testify later that she couldn't nail down a month, but she said it was before winter time. And if you take, and when the defense counsel asked her if it was November, October, September, she adopts that she doesn't know, or she states she doesn't know what the month was, but even if it was September, October, November of that year, she would have only been 13. And that's evidenced by her date of birth and the year that it took place.
But could it have been the fall of the following year, too?
That was not what was adopted at trial. And so I think here we have to look at the totality of her statements, and that the victim's testimony is evidence, and it's evidence sufficient to prove that she was 13. She didn't state, I don't remember the time that this incident happened, or in terms of her age. She couldn't remember the month, the date, but she can remember she was assaulted by this man indecently when she was around the age of 13. And I think also, if the court goes back and takes a look at the transcript when she's referring to moving on to the secondary incident, she's equivocal about those dates too, because it's hard to pin down when you're that age. But again, what she wasn't equivocal about was the fact that what the prosecutor asked her, did this man touch you indecently around this time? She said yes. And I would also point to the fact that if you do the math here and then look at the defendant's argument, he's adding an element of specificity that doesn't exist. As Your Honor, Justice Walsh pointed out, it's under the age of 14. The judge was knowledgeable about how the charge came out. The jury was knowledgeable and instructed on that they had to find that the victim was under the age of 14 for that first charge, and they did so. Here, in the light most favorable to the Commonwealth, looking at her testimony, looking at how it came out, looking at the math the jury was given, her date of birth, the timeline, that's what they came back with. Was
Is there a bill of particulars requested in this case, do you know?
Off the top of my head, I don't, Your Honor, and I apologize, but I can submit a 16L and let you know.
I'll check the docket.
Yes, but what I do know is that the jury were informed that they had to find that she was under the age of 14. And going back to the jury question, it was about when she moved, the timeline of when she moved. That was what their question was. It wasn't something, or it was not a question of was she under the age of 14 at this.
How do you respond to Sister Counsel's argument that this isn't about credibility as it is, and these are my words, not hers. Sure. She said it better than I will, that this is really about sort of two different theories of when things happened?
I wouldn't even state that it's a theory, because I don't think there are two theories here. There's one theory. She was under the age of 14. My sister points to the trainer as kind of on point with the specificity and the counter stories, but here, that's not what happened. Trainer has direct contradictory evidence. In Trainer, the victim's mother got on the stand and said, no, she was 14 when the defendant moved in, and therefore she would have been 14 at the time of the assault, because I believe that she stated the victim said the assault took place 6 months after he moved in. That's not what we have here. What we have here is the victim stating that she was 13 when this happened.
Okay, where does it say that?
Well, she adopted that she was around 13.
Around 13.
Correct, but
right.
Your Honor, you
And
have
so
to
you're saying
take-
that's enough to write in proof beyond a reasonable doubt on that?
Absolutely, because it's the victim's testimony. The victim's testimony is evidence. Here, it's in the light most favorable to the Commonwealth. The judge heard the entirety of her testimony, heard that she was born on August 15, 2004, knew that the timeline was that she moved to Claiborne Street around 2017, and the victim got on the stand and stated, this is when this happened. And that is sufficient evidence for the jury to find that she was under the age of 14. Didn't have to find that she was 13, had to find that she was under the age of 14.
But how about this is a little hypothetical, take it out of the age difference. How about if you have a victim who comes in and says, Well, it was either Mr. X who was the perpetrator, or it was Mr. Y. I mean, that's not enough to
I don't think we'd
submit
be at
that.
trial, if I may. I think.
Not enough to submit that to the jury, right?
Sure.
So it just strikes me as she's never come out and said, I was under 13, I'm under 14. She never said that at any point.
Well, she did by adopting that she was around the age of 13.
Around the age of 13.
But then they went back and did the math, or they did the math and stated that she could have been 12 or 13 in the transcript.
When she moved in.
Correct, and this took place months later. And so around that timeline.
Was there testimony it took place months after moving in?
I believe that it was that she moved to Claiborne Street, this incident happened, and she was, if you look at the entirety of her testimony, including the context of which cross-examination came out, it was around either before the winter time of that year.
But months after moving in, because that would be pretty critical.
I believe, that is
And
that is my reading of it. I don't believe at any point she stated it was, September of 2017, but taken with the context of the entire case at trial, the complaint says 2017. We know that we were there looking at this incident that happened, and if you can also take into account the defendant's own statements that this happened and that it happened at Claiborne Street. And so I think if you have to look at it all as the judge was looking at it in real time, and not just in a vacuum, but as a totality of what the testimony was to prove that point. There can be no doubt that there was an indecent assault and battery here, as the defendant doesn't argue that, and indecent assault and battery, as we know, is the touching. So the only element that necessarily the defendant has to raise here is age. But again, looking at the light most favorable to the Commonwealth, she testified that this was when this happened.
And this is just a curiosity, and you touched on it, saying that a case wouldn't be charged. I didn't see the application for the criminal complaint in here. Did she say, was there some indication in the application that she was under the age of 14? Because I'm curious as to how the case did get charged.
Sure. The complaint, the application isn't here, but the complaint is in here at page, in the
I did see
defendant's
that,
appendix at page 15. And it does state, excuse me, if I may just have a moment.
Again, it's just more of a curiosity if
Yep.
she was backing off her
Sure.
original statement, or if...
Correct, and it states, on or about July 2017, did commit an indecent assault and battery on a child under the age of 14.
Right, but what I mean is, in the application for the criminal complaint, what was indicated in that application? That, in other words, did she say that I was, 12 years old when it happened, or I was 13 years old?
Sure, unfortunately, Your Honor, I do not have the application. Again, if
Okay.
that's something
Again,
Your Honor would like to look
has
at, I
nothing
can
to do with
submit
the
it.
result.
However, I would say that that's not evidence before the jury or before the judge in his determination of sufficiency, and whether or not this should go for a motion for required finding. But I will say, again, in the light most favorable to the Commonwealth, questions of credibility. I do think this still is kind of a credibility question because she's the witness testifying this happened to me. The jury credited her testimony and determined that she was under the age of 14. And if the court has no further questions, I would rest on my brief.
I don't see any. Thank you
Thank
very
you.
much. Counsel, thank you both. Excellent arguments. The matter is under advisement. Our next case is Commonwealth versus a juvenile, docket number 23P988. And we will, after this case, we will take the morning recess for about 10 minutes or so. Attorney Carleen, good morning.
Good morning. Margaret Carleen on behalf of the juvenile. May it please the court. This appeal seeks to address two main issues in this case, two problems with this case. The first is that the motion to suppress should have been allowed because there was no reasonable suspicion to make the stop. The description that Trooper Best had when he made the stop was extremely vague under the case law. It is essentially...
The backpack, though, that backpack fact changed it for me a bit.
That was the best they had, that there was a backpack. This is a two-toned
two-tone backpack.
Two-toned backpack, black and gray. The problem with that is that this is downtown Quincy. It's extremely crowded, packed, urban area. The location of the stop is right next to Quincy College, where we would imagine an enormous amount of people are carrying backpacks, and black and gray is a very popular color. There was also a high school getting out at around the same time. So in light of that, it'd be one thing in an extremely rural area to see one black, one white male walking together. But here, downtown Quincy, it just seems a very commonplace. Again, that would have fit the description of an enormous amount of people. So for those reasons and others, the motion to suppress should have been allowed. The second problem was that the court permitted Officer Cleary to make an in-court identification despite having never made an out-of-court identification prior in the form of a photo array or a lineup.
So that one is interesting to me. I wanted to ask you, the way you drafted your brief, is the identification procedure and the jury error instruction that you claim, are they dependent on each other, or are they separate legal concepts?
Separate.
Okay.
But they're certainly, they can,
It doesn't help.
one compounded the other, I think is the way I would probably put that.
Okay. Do you agree as to the instructions that we're reviewing for substantial risk of a miscarriage of justice?
It's true that there was no objection specifically made to the jury instruction. That's
And
correct.
what about as to the ID?
There was as to the ID. So there was a motion in limine prior to trial. Commonwealth filed a cross motion to allow the testimony, but no good cause for that was demonstrated.
No what?
No good cause was demonstrated.
Okay.
So
What is the closest, if you have it, factual case on identification to yours?
I think we would just bring it back to the Creighton case and the policy that it outlines, which is, it's just the black letter of that case. This was clearly a mistake. And the error wasn't harmless. It's an issue where the outcome of the trial could have been changed. You had a police officer identifying somebody in court, and it was very easy for the jury to conflate the issue of who the police had decided to apprehend with who had actually committed the crime, which Officer Cleary never saw, never was an eyewitness to that crime, and also only saw the suspect from the back and the side. He never had a full view of the suspect.
What if it wasn't Cleary? I know this is not your fact pattern, but I'm just trying to test. Creighton has caused so many factual scenarios. I'm trying to get them straight in my head as to what if instead of Cleary, it was one of the bank people, and they didn't do an ID at the scene, but they were brought in to do an ID at trial. Same argument?
Same argument. My memory is Creighton is exactly that. It wasn't a police officer witness.
It was somebody in the library.
Yes.
But you would agree that Creighton involves the identifying the perpetrator of the crime by like a crime victim or someone who's a recipient witness to the crime, right?
Creighton stood for the, maybe I didn't understand the question, but Creighton stood for the proposition that unless good cause is demonstrated, first identification should not be in court because of the potential, because it's so highly suggestive. Essentially, the person testifying sees a defendant sitting at a table right next to their attorney and gets the idea that everybody has already pegged this person as the criminal. So it becomes now unreliable. Are they identifying this person from their own memory, even if they exhibit confidence? And I think Creighton was also clear that this can't be cured with a cross-exam or the witnesses being able to view the confidence of the witness in making the identification. Memories are too unreliable. So it was concerning.
Right, but that's aimed at someone taking the stand and saying, that's the guy that stuck the gun in my ribs. I mean, that's very powerful testimony. But that's different, wouldn't you agree, than a police officer coming in and saying, that's the guy I took into custody?
Yes, it's different because the police officer is at that point only testifying that this is the person that I saw running in a garage or that we had apprehended and wasn't an eyewitness. I think Creighton was very clear that to meet an exception, the officer would have to be an eyewitness to the crime.
Did neither one of you cited Commonwealth versus Gill, which came out in 2024. I happened to write it. It's about this exact issue. It wasn't a police officer, it was a civilian. There was not a prior identification. and I want to confer with my panel, but I might want you to look at Gil and send in something supplementary, because
Certainly, Your Honor.
part of me that thinks that Gil answers this question, and, spoiler alert, not in your favor.
Thank you, Your Honor. I will be sure to look at that
Let me talk to the panel,
case.
and if we want a subsequent briefing, I will let you know.
Thank you, Your Honor.
I'm just trying to find the site for you. So keep going, and if I find the site, I'll let you know.
Well, the first issue in the motion to suppress is that the stop occurred at the moment of the initial encounter between Trooper McDermott and Trooper Best. The circumstances there created a coercive environment. There were 2 uniformed officers there. There was a helicopter making a lot of noise up above. Trooper Best's first statements to the 2 individuals were, "Who are you and where are you going?" He then demands identification very quickly, and there's a case right on point on that. Once identification is demanded, the person is essentially immobilized and can't move. Also, the age of the 2 should have been considered. There's case law directly on that point that children are easily influenced, easily intimidated. There should be caution in applying this test to children.
Did the juvenile court judge not consider their age?
It wasn't mentioned in the transcript. I don't recall seeing that anywhere in the record.
Just by virtue of the court? I mean, isn't that something the judge is considering?
Well, this was just with respect to the motion to suppress. I think that I don't recall any particular discussion about the age of the juveniles in that. I think that at that point, the judge was just considering what was sufficient to make the stop. My memory serves, there may have been a reference to that, but that the other factors overcame it. But again, that's what we're arguing. The judge should not have found that. Taken together, these factors demonstrate that there was a coercive environment and that the stop should have been found to be at the point of the initial encounter. One of the suspects was also black. There's also case law that refers to the extreme caution that should be taken. I understand that the suspect at issue is white, but when you are with someone, it stands to reason that they may have felt the same concern. So that was a factor that should have been considered as well.
When do you say the stop occurred?
I'm sorry?
When do you say the stop occurred?
At the moment of the initial encounter between Best and the individuals. Best
Not
and
when he went to do a pat frisk?
We believe that the stop occurred before that because all of these coercive factors were there. There was no reasonable...
Because of the helicopter and...
Well, there was a canine dog, and to be clear, I'm not sure that the dog was actually... It's unclear in the transcript. Was the dog there, right there next to the boys when the trooper...
That's one of my
questions. It's not clear, but there was a dog there. There's a loud helicopter. The radio is chaotic and making a lot of noise.
How much time from shots fired to this scene?
That's an interesting question because the cases that the Commonwealth cites where they're saying, don't worry about the vague description because the proximity of time really overcomes this, those cases really talk about a matter of mere minutes. This case, and again, it's not entirely clear in the transcript how much time elapsed, but it appears to be about an hour. I think Best testifies that he started responding about 2. And the calls came in a little after 1 when this first occurred. There's another witness that testifies he saw something, the 2 suspects or something like that, between 1 and 1:30. So it's a little unclear, but it appears that more than minutes had elapsed between the commission of the crime and the stop.
Do we know how far the stop was, what you say the stop was, from the scene of the shots fired?
I would have to go outside the record, but if the court would permit that.
That's okay.
Isn't this like Commonwealth versus Mercado, where the shooting takes place in downtown Worcester and police officer is directed to a store and he approaches the store and he sees 2 individuals coming out of the store and he just says, "Hey, what's up?" And goes up to him and starts talking. That wasn't a stop.
That wasn't a stop because that didn't create a coercive environment with a compulsory dimension. I think that the constitutional protections are only invoked once that happens. So the cases talk about that. We're saying, hey, can I talk to you? That is not going to be a seizure. But where somebody trails somebody in their car or stops and demands identification or asks them to remove their shoes or something like that, then, or a car is blocking them. These are situations where somebody may feel immobilized, like they can't physically move. There's a different case. This is a parking garage that's walled in with cars parked, packed in, making it very difficult. I think an adult in this situation would not have felt free to leave, let alone two juveniles. And there's a case that a stop occurred in a parking lot. That one, they did not find that that was unconstitutional because it was open and the person was engaged in casual conversation with his friend walking. This wasn't like that. This was a stop. The trooper admits that the boys looked nervous, and that's about all he really had for this stop, aside from a very vague
Well,
description.
they match what you describe as the vague description.
A vague description, which any male, white and black male walking together would have been fair game under that description. The case law is clear that dark clothing is not sufficient, and that's really all that there was. I think it's the exact description was two skinny teenage-looking males, one black, one white, dressed in all black, one carrying a two-tone black and gray backpack. And again, given that the area was filled with students, not only from a local high school, letting out of school at that exact time.
We know there's a high school, we know there's a college. How do we know the area was filled with students?
Reasonable inference. I don't think there's anything in the
Was there
record.
testimony?
There wasn't anything in the record, but there was testimony that the high school was letting out at that time. There was testimony of that. Also, there was testimony, I believe, I'm not sure which witness it was, that many of the students parked in that garage to attend Quincy College.
Can I jump back to the identification?
Yes.
I know you don't have a lot of time left, but you say there was incomplete jury instructions. To your knowledge, did she read from the model jury instructions?
The model jury instructions were used. The complaint is simply that there were omitted instructions which bear on the issue.
And the defendant, or the juvenile, I apologize, asked for the three pieces that were left out, he asked for those?
No, there was no objection
There
to
was no
those.
objection,
Right.
okay. So now we have the benefit of hindsight, we're looking at the model instruction, we're looking at what was given, and that's where you determine that there's something missing.
Yes, I think the argument is simply that justice would require to include those, particularly when that was a major issue in the case connecting this defendant to the crime scene. Not a single witness in this case could identify who the shooter was.
Are
So-
the three things that are missing, you know how the instructions have sort of what I would call the mandatory instruction and then the subparts of additional instruction? Were these additional, or are these from the actual, I just don't remember, the instruction itself?
To be perfectly candid, Your Honor, I don't recall. I'm not sure.
I'll take
I remember a long stream of words, but I'm not sure exactly where that ended up. But I think the argument generally is that the Commonwealth muddied the waters because they presented identification of somebody running away in a garage and not somebody that committed a crime. There were no eyewitnesses to that crime, so it was not relevant. It was prejudicial, and the crucial link to associating the defendant with the crime. So it was not harmless.
The defense was misidentification, it wasn't me, right? That was the defense.
Well, it was, of course, the Commonwealth's burden of proof, but
Sure.
that is the argument, that there was no identification.
You know,
And-
you said the police should not have done the one-on-one show-up with the officer and so forth. What was the alternative to that? Would you have the officer sit down and look through a photo array?
Well, there was plenty of time to do that. They could have done the photo array, or they could have done the lineup. And to comply with the law, that should have been done, and that would have cured the problem. But it wasn't done. And the error wasn't harmless because it could have conflated the issue in the juror's mind. It was confusing and may have impacted the outcome of the trial. If there are no further questions, I would rest on the brief. Thank you.
It does not appear there are any. Thank you, Attorney Carlene. Attorney McGee.
Good morning, and may it please the court. Michael McGee for the Norfolk District Attorney's Office. On that last point, Commonwealth versus Creighton speaks absolutely directly to that a show-up identification in the aftermath of a serious offense, such as a gun firing in a Quincy Center, is absolutely appropriate and reasonable under those circumstances, not only to identify the suspect, but also rule out suspects and to protect the safety of the public. Starting with the threshold inquiry issue and the attempted pat frisk. I know Your Honor likes lists. For the threshold inquiry, the knowledge that the shots had been fired in broad daylight at 2 p.m. in Quincy Center, the descriptions of the suspects, 2 skinny, teenage-looking males, 1 black, 1 white, both dressed in all black, 1 carrying a 2-tone black and gray backpack. The geographic proximity, the direction of the flight here was that Trooper Best searched President's Place parking garage, which is adjacent to 1250 Hancock Street, directly across from where he was speaking with the Quincy police officers when he arrived on scene. That was before the judge. And then the temporal proximity here. And that was a little bit not clear at the...
We don't really know from the time of shots fired to the stop how much time elapsed.
Yes. I will try to help. The one critical piece, and I know this was relied upon by the motion judge, was that he went there directly. So he went there immediately. This is right adjacent to the scene. That was at page 58. The call came in at 1:51. That's pages 6 and 18. Officer, it was the first witness at the motion to suppress hearing. He interviewed 3 witnesses in 10 to 20 minutes. That was at page 23. It took 20 minutes for that officer to clear the temple. That may have been Officer Cleary, actually. And he put out a bolo the Officer Cleary put out a bolo when the black male and the bag were secured close to, quote, mid-afternoon. That was the question that was posed by defense counsel, and Cleary responded a little bit later than the call came in. So I tend to agree with counsel somewhere in the hour range. If this call came in at 1:51, it took him a few minutes to get to the scene. It took him 20 to 40 minutes to clear the temple area and go across to the train station.
Is there anything in the record, I don't want to go outside the record, that tells us the distance from where the shots were fired to where at least your sister says the stop occurred?
What was clear from the record was that the Trooper Best arrived on scene, spoke to the Quincy police officers, and directly across from him was 1250 Hancock Street, which was adjacent to the parking garage. That's what was. What was also, I think, clear from the record was that when Trooper Best went into the parking garage, he only saw these 2 individuals coming out of the stairway. He didn't see a crowd of people. He didn't see a line of students coming from Quincy College or anything like that. I would also suggest that the inquiry that was done by the trooper fell well within a threshold inquiry. He asked them, he went up to the white male, said he was a student at Quincy College. He asked for an ID. He gave him a debit card with the juvenile's name on it. At this point, he started seeing both males looking around, placing their hands in their pockets, appearing nervous. Trooper Best brought up the shooting. They became more nervous. The black male, when asked if they had any weapons, said that he had a knife. This is Trooper Best by himself with 2 individuals, doesn't know their age. He knows that one says he's a student at Quincy College, he could be any age, gives a debit card, and the other individual says he has a knife. They're putting their hands in their pockets, they're nervous. He asks the juvenile about a backpack. He steps away and tries to block the backpack and disclaims ownership of it. At this point, a pat frisk absolutely would have been appropriate.
And that's where you say the stop occurs?
Yes. When he reaches for the arm and of the juvenile, of the juvenile.
Because he's concerned for his safety.
Absolutely. He's got an individual that says he has a knife, another person that's hiding a backpack behind him after a shooting at 2 p.m. in Quincy Center.
Can I ask you to leapfrog over to the identification question? One thing in your brief, on page 26, and certainly the evidence about what he did with his hands to get rid of the gunshot residue, presumably, is interesting. I don't know how that relates to the identification question.
Okay. What I would suggest is that identification for this case was a circumstantial, and certainly the Commonwealth's entitled to prove beyond a reasonable doubt based on circumstantial evidence. What counsel suggests is an error about Officer Cleary's testimony coming in was just a piece of that puzzle. And differing, and I think a little bit from the Gill case, is that Officer Cleary was simply testifying that he confirmed that the person was the person that the juvenile was the person that was arrested, that he was
Not the person that committed the crime.
correct. And that's a significant issue that was raised not only as something, a prejudice that we should be concerned about in Creighton, but in subsequent cases. And I saw a case, Matos, 95, Mass Appellate Court, 343 from 2019, that talks about that he was merely showed that the ID was merely to confirm that the person was the suspect arrested.
Well, how does evidence of consciousness of guilt relate, and maybe I'm not articulating your argument properly, but I read your brief to say consciousness of guilt evidence is relevant to the Commonwealth meeting its burden to show why there was good cause for an in-court identification. Am I misreading your brief?
Slightly.
Possible.
I would suggest that it's one of the bases in this circumstantial case about whether the defendant was in fact the person that was the one that committed the crime. So for the crime end of it here, you have an eyewitness who views some photographs from Santander Bank and is able to identify by the clothing that the person is, that the juvenile is the person that committed the crime. You have a debit card that's handed to the police officer that has the juvenile's name on it in the parking lot. And then you have a police officer who's identified that person that left the debit card in the parking garage as the suspect that he saw on Furnace Brook Road. And then you have that same individual, when they go to do a swab for his hands, takes his hands and puts them in the toilet, which the prosecutor appropriately asked the jury to infer that that was to remove any gunshot residue from his hands, based upon all of that circumstantial evidence that this is the person who committed the offense. And they had the photographs also to view themselves and consider. So that's why I would suggest.
Creighton, the person whose ID was at issue was somebody in the library that saw what was on the computer, right?
Yes.
So that was somebody who was able to, or was offered to testify that Creighton was the guy who had the child pornography on the computer.
Yes. And the danger inherent in that is you had the eyewitnesses to the crime.
And you're saying here, that's all well and good, but all Cleary said is the juvenile is the one who was arrested. Not that he was the shooter or the person that had the gun, just that he was arrested.
Correct. And the dangers inherent in.
That's what makes it different.
Yes. If this were Richardson or one of the other, or one of the bank persons, that was the danger that they talked about in Creighton, that these two young people that saw the defendant watching child porn, then 2 years later made their identification for the first time and said, that's the guy in court who's sitting at counsel table's desk, is far different than a police officer who was at the scene of the arrest that is not where the commission of the crime occurred.
So why does it matter that the juvenile was the one that was arrested?
Why does it matter? It doesn't. And I think it's part of from the prosecutor's standpoint, it was part of the building blocks of the circumstantial case, but it doesn't matter in the sense of prejudice here. And also, and I just.
What if the Commonwealth hadn't put in that testimony?
If the Commonwealth hadn't put in that testimony, they'd still have a pretty strong circumstantial case that from the photographs, the eyewitnesses, his consciousness of guilt at the police station, and leaving the debit card.
I think guilt doesn't matter anymore, so don't worry about guilt.
And the debit card with his name on it, I think would be very helpful to the Commonwealth's case as well. Unless there are any other questions, I'd rest on my brief.
Just, do you happen to know off the top of your head if what your sister is pointed out for the three things that are missing from the instruction were part of the standard model, or were they the add-ons that I call them? Do you happen to
I believe they're
remember?
add-ons because they would only apply, there's three here. So there's the show-up that was given. So interestingly enough, what was at play here was a show-up identification by a police officer. So that was given. The two other instructions were lineup, which there wasn't a lineup here, and multiple identifications. And arguably, there was a prior identification at a motion to suppress hearing, but again, counsel didn't request that instruction. We don't know if that was tactical or not, because that would have to bring up the motion to suppress hearing as well.
Let me just check with the panel. I don't see any other questions. We're happy to take the rest of your argument on your brief.
All right, thank you very much.
Counsel, thank you both. Excellent arguments. The case is under advisement. We are going to take our morning recess. Mr. Guarino, are the rest of the cases here? Excellent. Thank you. All right, we'll take about a 10-minute recess.
All rise. Court is open. Please be seated.
All right, before we get started, just because I know some folks have joined us for the last 3 cases of the day, I just wanted to repeat what I said this morning, which is just a reminder. I know we have a lot of veterans here, but we have some new folks that each party is permitted 15 minutes of argument. If you're splitting your time, I know you've let our timekeeper know that. There is no rebuttal. We have read everything, so you're best to get to your arguments. With that said, Attorney Spanos.
Good morning. May it please the court, I am Attorney Spanos, and I'm here representing the appellant father today. Father's position, even prior to the removal in this case, was that he was able to care for his child with the assistance of his family. And arguably, the removal took place largely because of DCF's known concerns about the mother's mental health. They really didn't know much about father at the time, and
Can I ask you, though, so I understand how you have framed your argument with respect to reasonable efforts and ADA accommodations, but I just want to be 100% clear. You are challenging the termination?
Yes.
Okay. So you also say at page 26 of your brief that the department failed to hold an ADA meeting. Now, as I go through the record, and I'm happy to be wrong, and please tell me where I am wrong, the only thing I've been able to find is that father's expert makes some recommendations about what he would need or would be helpful to him in order to visit and parent the child. I don't see a request for an ADA meeting, so can you help me with that?
What I can say, it's not my understanding in reading the department's own policy that it's up to the parent to request a meeting. I think the emphasis is on the department to realize when they're working with the family and they recognize that they have a parent or a child in their custody, that they should be on their own raising that issue. And I believe it was actually asked at
I
trial.
guess this is going to the question of waiver, because under Daisy and Yelenia,
And Gregory.
we have to have something done below. And so what opportunity did Judge Gershengorn have to address this in the first instance in the juvenile court?
To me, and maybe I'm reading this wrong, the request has to be made to the department for an accommodation.
So did Dad do that? And if
Dad's
so,
expert wrote the letter, which was provided to the department, saying that he required an accommodation and that the recommended accommodation was to lengthen the visitation time because he learned best by modeling.
I thought it wasn't so much to lengthen it, but to have it more frequent so he could see the pattern. Maybe we're saying the same thing.
I think maybe we are. I think it was.
So expert puts this in writing, and then, to your argument, department doesn't do it. So now, is Dad required to request an abuse of discretion hearing in the trial court? Is Dad required to request a fair hearing in DCF? What does Dad do?
I would argue no. I don't think that it has to go that far. And, you know, stepping...
What do our cases say?
Well, I don't say that, in adoption of Gregory, I don't recall it being that they have to actually file an argument in court, or file for a hearing in court. I do not read it that way. And I also will recommend, because in my argument, I believe the similarities are real between adoption of Chad and this case. And I represented the mother on appeal in Chad, so I'm very familiar with those facts. And to me, this is a case where the issue was Dad's got some sort of cognitive limitation, and everybody knew it. I mean, it wasn't that this was a surprise to the department. They knew it. And he needed some help getting together services in place. And the difference, I can tell you, between adoption of Chad and this case is in Chad, the mother had no family supports at all. which was why she was originally in the custody of DDS, and there was a dispute between the agencies. Here, you've got a supportive family that actually was around all the time. The grandfather was in court every single time. The aunt was very available. There's a lot of issues about why the aunt didn't fill out the paperwork. And I think that there very likely was some cultural differences there. I mean, if you read I'm sure you read the transcripts, it was challenging to understand. It's my first experience, hearing a Jamaican, person. It was very hard to understand. And there were questions raised about whether Dad could read. And we don't know if that was because he couldn't read, or was there the language difference that was also impacting?
I thought, and again, if you see it differently, especially where you were counsel, I thought, Chad, we were pretty critical of the trial judge and the lack of findings and analysis. By contrast, the judge made some pretty significant findings and analysis about Dad's needs, Dad's limitations, what was sort of in his orbit to be able to assist him. To me, that differentiates Chad. Can you speak to that?
Well, for example, in this case, the request for a parent aid, I was really personally frustrated by the fact that this parent aide, who supposedly was someone who worked specifically with people with, some kind of cognitive delay, they kept the case open for 6 weeks and then closed it because there was a so-called lack of follow-through, what they saw.
DCF gave him a second one.
But then DCF, they made a recommendation, or they put out a request for a second one, and then didn't help Father file the intake paperwork, which became a problem. And the judge actually in trial questioned the DCF supervisor and said, did you do this? And her best response was that, well, the social worker once a month would go over things. And that's another problem in this case, is that, and I know I think it's a relatively newer thing with DCF, is that they don't always have the ongoing worker supervising the visits. They've got this tech person in there. So you don't have the same consistency, and that I think someone who has what Father's limitations likely are would really benefit from having the same consistent person contacting him. I think it adds to the overall confusion. So I had a problem very much with the short attempt at providing a parent aid for him. I raised the argument about an ADA meeting. To me, when I read the new policy, when they see a client that they believe, they don't have to have a diagnosis. If they believe there's a problem, they should be holding one, and this is the very reason why.
Isn't that what and I know what happened, but isn't that what the referral for the neuropsych eval was?
And yes, and it would have been, and this was another thing I think factually was confusing for Father, because he had the district court case going on, and I think there was some issues. Other people were saying to him, no, you don't need to do this. You don't need to do the domestic violence program anymore because your criminal case is over. But DCF didn't see it that way. And there was, I think, a disconnect between what the father was hearing from the multiple providers that he was working with.
Where is the connection between, and if there is, between your argument of reasonable efforts and the failure or the violation of what you claim is the ADA? So when I look at what would be reasonable for, everybody agrees in this instance that there was an individual, the father, with cognitive disabilities. And we could argue about whether the department made reasonable efforts by doing the referral, by having the parent aid, by trying to kind of redirect, et cetera, et cetera. But it seems to me that with the American with Disabilities Act, if it's not waived, that there would be a manner in which someone could claim and raise their hand and say, I need accommodations, and this is a violation, what you're doing right now, versus going to trial, having a finding, and now later, after the fact, raising this. And I'm just wondering where the two, if at all, meet in the analysis.
to me, the burden is on the department. I just read it that way. I mean, when they have a person who's walking in that is clearly impaired in whatever way, I think it should be. We shouldn't be leaving it up to the disabled person to be the one who's got to raise that. And the other thing...
What should the department have done?
They should have held an ADA meeting. They should have known right off the top. And I have to believe...
It resulted in a referral for a neuropsych eval, a parent aid.
No, the way I read it is, I think it should be a collaborative meeting, and where you had this man's family, and that was really around all the time anyway, if you had brought them in and everybody sat at a table and you had an open and conversation where everybody could have gotten on the same page, and I just don't think that they were.
Yeah, but the record belies that, right? I mean, Grandpa sounds like a great guy, but he's not available to help Dad parent. He's working crazy hours all over the place. Grandma doesn't fill out the ICPC paperwork. I mean, is a social worker supposed to be with him 24/7 to...
No,
right.
no,
So
absolutely not.
what were they supposed to do?
What was also frustrating to me was, I think the social worker said, well, she handed in the paperwork, but it was incomplete. And we don't know, based on this record, what was incomplete. Was it something historical? Was it something, regarding a criminal record? I mean, we just don't know. But even at an ADA meeting, you could set up a time. Okay, the aunt is, and she was the aunt, not the grandmother. The aunt can come in and we will go over what is incomplete, because it wasn't clear to me.
Does the aunt need accommodations? Why does the
No,
aunt get accommodations?
Well, this is where I point to the cultural differences. I don't know that the grandfather or the aunt really understood what state the regulatory process of state intervention.
Dad have counsel this whole time?
Yes, and it was Dad's counsel that hired that expert who did the parenting evaluation.
To your point about what family members would say in a collaborative meeting, didn't the grandfather say that the father was essentially as right as rain, that he was fine?
No, well, and again, you know what? I really wish, Your Honor, that it was hard to read the transcript and really get the full flavor of what Dad was saying, because his language was different. But what I saw, and the new DCF policy actually covers that some parents and family members are unwilling to come out and say, my son is, or, I have a disability, because they're afraid that that's going to just disqualify them, from parenting. So I think what the father was saying, because at one point the father refers to the boy's school, and he says, well, maybe he didn't go to the best school, but he works hard, and he does, so if you train him, I mean, he was working in demolition, so Dad could do demolition, and he can make money doing demolition. Maybe he could work at Hertz Cars and wash the cars all day. Now, that's a good, valid job. And Dad worked, his father worked hard, and you're right, Your Honor, I think the grandfather was very proud of his family. And, DCF doesn't hold that back on them. That's a positive. So I think the failure to hold an ADA meeting in this instance, where you have valuable family members, maybe grandfather couldn't be it. I would have said it was Aunt Rosemary would have been the better caretaker, but Dad's sister had also just come in, and she was present and available to help.
Can I ask you, and maybe I missed this, is there something either in your brief that I can't find right now that you could direct me to, or just in case law, that requires the department in instances such as this? So I understand your argument to be, well, it would have been great to have an ADA and for this collaborative effort to occur and for everybody to listen to one another and figure out a plan. But the department didn't sit on their hands and do nothing when they recognized that there was an individual with some limitations, some cognitive limitations. And what they did appears, from at least this side, to be entirely reasonable. Let's set up with a neuropsych evaluation, which he didn't do. So where is it, other than, gee, it would have been nice for everybody to sit down? And I don't mean that disrespectfully,
No,
because it would have been nice, right? But where is it in case law or CMR or anything else that says this must happen?
Well, when I read through the department's policy, and I believe I've attached it to my brief, I think the department, when they see a person, and in this case, and I mean, especially where in the beginning it was the mother and the father, and the mother had very significant diagnoses, that they just it should be a practice that the department should just by rote do every time they see that. Am I answering your question, or am I?
I think you're answering what you'd like the department's policy to be, and
Well,
citation to that it was there. But I'll take a look again at the policy.
I mean, I look because I can see my time is running out, but when I look at adoption of Chad, and the Chad court did not remand the case because they knew that the mother was fit. In fact, they came right out and said, we don't know. And I have a feeling, it's my argument, and our argument today is that the information isn't in the record to show that termination at this point was the right step.
And we will have to leave it there.
Thank you.
Thank you. Attorney Braithwaite, are you arguing for 10?
I am, Your Honor.
Okay.
Thank you. Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court. There was abundant evidence that father was unfit, that he was unwilling to avail himself of the services offered to ameliorate his parental deficits, and that it was in the best interest of the child that parental rights be terminated.
Can we I want to make sure, Mr. Guarino, are we okay? That's okay. As long as we're still recording, we're good. Okay, I apologize. Technology is not my thing, but.
Not a problem. I think if I could, I'd like to start by answering, Justice Walsh, the question that you had put forth, if that's okay, about the ADA. I would like to direct the panel to the Department's disability policy. It's number 2022-011A, which says an ADA meeting is defined as a meeting held between department staff and a parent and their counsel, if applicable, when necessary, to discuss a parent's disability-related needs and requests for a reasonable accommodation, or to review a disability-related complaint and discuss potential resolution. And I think the answer to the question that you were asking is in the words, when necessary. This is not a mandatory meeting, but rather is one tool available to the parties when someone presents with limitations.
Can I make an observation, though, from the trial record? And I often shoot the messenger, so I'm going to shoot the messenger. But there's got to be better training for these social workers. Her testimony about her awareness about the requirements of the ADA was woefully troubling to me, woefully inadequate and troubling to me. And this case is all about his limitations and his need for accommodations. Put aside from a legal perspective, we'll talk about that in a minute, but the social worker, I know you have trouble keeping social workers, and they're young and they don't get paid well, but this record was troubling to me. She just didn't know anything about the ADA on her direct or cross-examination. So I'm not shooting the messenger. If you can relay that back to the trial counsel division of your department, that would make me very happy.
I will absolutely do that, Your Honor.
So now on the legal perspective,
Yes.
okay, I know what the definition says. You've just read me the definition. What does that mean as a practical matter? So I think it can't be contested that everyone knew he needed some level of evaluation, right? And so you send him for a neuropsych, which is the right step in my view. But if you have somebody who has what appears to be cognitive limitations, do you just say, here's the phone number, go make an appointment? Aren't you setting him up for failure?
Well, I think if that's what we had done it would have been, I won't say setting him up for failure, but inadequate. But I think the record reflects we did a lot more. The social worker, and I do not dispute the testimony was woefully inadequate, and I will relay that message. But I would point your honors to the record, which reflects, with regards to the neuropsych evaluation specifically, the efforts that were made were extensive. In this instance, the social worker went above and beyond. She not only made referrals, she explained the process, she helped him complete and submit his intake paperwork. She reminded him of appointments. She provided information on transportation and offering to pay for it. She helped him reschedule his appointments when they were missed. I know your honors are aware of this, he indicated a refusal to participate. It wasn't simply the case that he would miss appointments. At times he said, I don't need it, I don't want it. And the social worker, because she did have experience working with adults with cognitive limitations, she did not take that to mean he was non-compliant and the story was over. She sat down and she explained to him, and the record reflects, she said, this isn't a judgment on your intellect. This is to help us know how to reunify the child to you. So this is a social worker that, while I agree, sending him out to do the paperwork, that wouldn't be enough in this case. And I think these cases are all very fact-specific. I would argue that an ADA meeting wasn't appropriate in this particular case, or at least it wasn't the most valuable tool, because the reasons for an ADA meeting weren't really at issue here. There wasn't a dispute between father or father's counsel and the department about father requiring more services. To the extent that my sister speaks to the visitation time, the record reflects that a month prior to that parenting expert indicating that there should be more time, father told his social worker, I can't do visits, they conflict with my work schedule. Within 24 hours, the social worker had changed the father's visitation schedule and worked with him around how to communicate with his work so that he could still attend visits. So that happened in March of 2022. In April 2022, as your honors know, the very day before that letter was received by the parenting expert, father again, 1 month later, says, I can't keep up with my visits. And there was a long conversation with the social worker and the social worker supervisor, I believe, with father about how he could still maintain his visitation. And so
Is the meeting not necessary because you were already, DCF, I apologize, already doing what you were supposed to be doing?
DCF was very much already doing what we were supposed to be doing. And the meeting is usually called by, it could be called by it can often called by a parent, but it can be called by the department for sure when there is conflict. So if you had father's counsel saying, father doesn't need a neuropsych, well, now we have trouble because how is father going to succeed at trial? He should follow his lawyer's advice. The record reflects, and I believe it was, I think it was fact 98, but I can let the court know if they want. The record reflects that the father's lawyer was in support of the tasks that were put on father's action plan. And so the disputes, and the other thing that my sister references is that it's a meeting that can help bring parties together and put them on the same page. And in this case, as Judge Gersh, as the trial court judge indicated, the department took what she called a team approach. The department worked with collaterals. The department worked with the family. The department tried to engage paternal aunt, tried to engage paternal grandfather to the extent that he was able to. And one good example of that was with regards to the neuropsych evaluation and making a plan with paternal aunt present around how transportation would go. So all the parties were on the same page, and an ADA meeting was not necessarily the appropriate tool in this case. If one had been requested, that should have been honored, but that wasn't what was sought, and it doesn't appear that that's what was needed at that time.
So then he would have had to have brought a challenge below in some nature of an abuse of discretion hearing before the trial judge or some kind of a fair hearing request with the department?
Yes, Your Honor. Our argument, our position is that given the nature of the challenge with regards to reasonable efforts, that claim has to be made before the trial court so that the trial court has an opportunity to respond to it. He could have filed an abuse of discretion motion, as you indicated, engaged in an administrative fair hearing or a grievance process, or commenced an action under the ADA. And I would point the court not only to Gregory, but to adoption of West as well, in support of the position that after the trial ends, it's just too late to make that argument. I would also like to say, even if this panel were inclined to assess the department's efforts, they were reasonable. They were, in fact, Exhaustive was a word used by the trial court. More than reasonable was a phrase used by the trial court. This was a case where father, unlike Chad, was not open to support, he was not receptive to services. And the big distinction, as I see it, between Chad and the case here is that in Chad, we had a mother who took a 40-hour parenting program. She did a parenting evaluation. She was willing to work with one-to-one support through DDS for a period of years, and the record reflected that that supported her in parenting. Here we had a father who would be in visits, and he was affectionate, and I have compassion for his limitations, but even when he would be told, those clothes aren't proper, he would insist, nope, I'm getting the 24-month clothes for the 5-month-old, or your child at 5 months is not yet ready to walk or hold the bottle on his own, and he was insistent. So this is a very different set of circumstances, and as Your Honor already indicated, the lower court extensively addressed whether family could help, and they found the paternal aunt had not proven herself as someone who would be available enough, and the paternal grandfather, though loving, was too busy. And she considered services in the community, a one-to-one aid, a parent aid. She was pretty thorough in looking at what could be done, and she determined that father's refusal to work with services meant that those wouldn't be successful, and that ultimately, were she to put the child back into father's custody with any amount of family or community support, the child would remain unsafe.
Don't see any other additional questions, counsel. Thank you.
Thank you very much, Your Honors.
Mr. Carter, are we okay to keep going? Okay, got a thumbs up. Attorney Grantham O'Brien, 5 minutes, is that right?
Yes, ma'am.
You may proceed.
Good morning, Your Honors. Tamika O'Brien. Can you hear me okay? Okay, thank you. Your Honor, the child's position in this case was that at the time of trial, father was unfit, and it was in the best interest of the child that father's parental rights be terminated to free him up for adoption, to be adopted by the family who he had lived with for almost his entire life. Your Honor, I think that the ADA issue was well briefed and addressed by my sister. So what I would like to talk to you about is, from the child's point of view, there was domestic violence here. It's not just the child's point of view, it's the court's point of view. The father had 2 children with 2 separate mothers and had physically assaulted both of them and had been arrested and charged with assaulting both of them. In this situation, while mother was pregnant with this child, father had assaulted her in 2 separate occasions. So while we can argue that perhaps father didn't have the capacity to attend the domestic violence training, the fact remains that domestic violence was present in this family's life. And as we know in Vaughn, it has a profound impact on a child when they are raised in a domestic violence situation. Another issue was father's housing instability. He testified that he liked to move around, so he was often at hotels. Sometimes he was in New York, sometimes he was in Rhode Island. So he didn't have a stable, not even a permanent, but a stable place to bring the child to.
Did the judge make an error about his employment at the time of trial?
There was some confusion about that.
Even if she did make an error, does it matter for the result?
No, we're looking at the entire record here, and the entire record is what has to be looked at. Father was employed, I think, but also his employer was a longtime family friend who told to DCF that he was giving him odd jobs, that father was misguided. So it appears to me that while father was employed, I'm not entirely sure that that employment was steady. I'm not entirely sure he had the capacity to retain steady employment. I do want to take 1 minute to distinguish, and I certainly am not as well versed in Chad as my sister here is. But when I was reading Chad this morning, I kind of looked through it again, and I thought the thing that I got out of Chad was that in Chad, the trial judge didn't consider whether the mother could leverage the supports necessary to keep the child safe and meet the minimal adequate parenting. In this case, the trial judge did consider that, and she said, well, father does have supports, his paternal grandmother or grandfather and the aunt, but neither one of them were really as invested, and for various reasons. Grandfather worked 13 hours a day in Boston. A lot of times he would stay over in Boston from Rhode Island, so he wasn't as available. And then, the aunt dozed off during visits, and so I think that the trial judge in this situation made the right conclusion that even with father's loving support system, he wasn't going to have the kind of supports that he needed to keep this child safe and to meet this child's basic needs. One of the issues that the trial judge made, and I don't remember exactly which finding, but the child needed surgery for an undescended testicle. And while this is not a life-threatening issue, the trial judge did note that the father had trouble even filling out the paperwork for other services. How is he going to be able to manage this child's needs and meet this child's needs? So I think, again, I have great compassion for this father and this family, and I'm sure that cultural issues really did impact. The trial record was difficult to read, but at the end of the day, unfortunately, this father and this family could not meet the needs of this child, and this child had a pre-adoptive home, a loving pre-adoptive home, who could meet those needs, and it was in the best interest of the child to terminate the parental rights. For that reason, Your Honors, the child asks that the lower court's decision terminating father's parental rights stand.
Just make sure we do not have any additional questions. Counsel, thank you. It's a very difficult case. It was very well briefed and argued. I want to thank all counsel. It is now under advisement. Thank you all.
Thank you, Your Honors.
Our next case is U.S. Bank Trust versus Donald Perry, docket number 23P962. Good. Back up on you too, in case you were worried about your nuances. All right, Mr. Perry, when you're ready, if you could come to the podium, and the clock will begin when you begin to speak. Good morning.
Good morning. I'm a little unclear what I should be arguing here today. Is it the motion to dismiss that I made or the appeal itself?
So, sir, what's before us today is your appeal.
Okay.
And you have filed a brief in which you raised several issues, and it's up to you which order you would like to take them in.
Okay, so I'm not arguing about the motion to dismiss.
You have appealed, as I understand it, from the judgment of possession that entered in U.S. Bank's favor in a post-foreclosure summary process action. That's my understanding of what you have appealed. And in that appeal, you have raised three issues as you've addressed them. One is whether the trial court acted ethically in ignoring an order, whether the judgment in the second motion for summary judgment was supported by the facts and law, and whether the bank's attorney acted ethically to the court. So those are the three issues that you've raised in your brief.
Okay, but I also filed a motion to dismiss separate from my brief.
Sir, the issue that's before us today is the appeal as I've just described it to you.
Okay, all right. Well, on the appeal, I'm appealing it, and what I contend is the lower court judge misrepresented, misconstrued the facts of the case that led the first appeals panel that looked at this exact case, the same facts, and led them to vacate the decision. The appeals court did not, as this lower court judge claimed, limit its reasoning for vacating the decision that allowed that the first summary judgment was whether the mortgage assignment was made in 2011. That was a false date submitted by the attorneys for the plaintiff, and which is lower court judge characterized as a Scrivener's error, and it was hardly that.
Mr. Perry, I'm actually going to stop you because, fortunately, Justice Hodgins just showed me, I have never seen before that on September 12th, you filed a motion to dismiss.
Yes.
Is it to dismiss your appeal in this case?
Well, the dismissal, the argument of dismissal is that the lower court judge essentially substituted her opinion rather than any new facts, and so that this case should never have come back to the appeals court. It should have been decided it was decided by the first appeals panel that took it. They remanded it back to the lower court.
But you're not withdrawing your appeal, right?
No, I'm not withdrawing. What I'm saying is the motion to dismiss should supersede the appeal itself, because if you grant the motion to dismiss, the appeal wouldn't be necessary.
Okay, so you should feel free to argue both then.
Okay. Well, all right, so the argument for dismissal is simply this. I mean, the first appeals panel reviewed the case, they vacated the judgment and sent it back down to the lower court. Whatever leeway the lower court has, it does not, in my opinion, and I believe in the opinion of case law, does not extend to her substituting her opinion for that of the higher court. And that, I contend, is exactly what happened. In the motion for second summary judgment that they made, the lower court judge herself declared that, one, discovery was closed. Then later, in her interim order, she said, I find that they have not produced any evidence to satisfy the orders of the first appeals panel that were remanded back to the lower court. She then, in her final judgment, she allowed the summary judgment. So, by deduction, the only thing that changed was not the facts, but was her reinterpretation of those facts. In other words, her opinion. And I believe that that's a fundamental something that shouldn't be allowed. I mean, we have a hierarchy of judicial system in the Commonwealth, and again, while the lower court has some leeway, I don't believe they have it doesn't extend to them just simply, substituting their opinion, as I've explained in or delineated more in the actual motion that I've submitted. So that is my argument for dismissal. That dismissal should happen because the lower court judge did not carry out the remand orders. It's as simple as that. And I believe that goes against a fundamental construct of how we operate in the Commonwealth. There's a hierarchy of the judicial system, and this lower court judge is simply chosen to ignore it.
Okay, so you're saying that discovery was not complete?
No, right. I'm saying discovery was not complete, but I am saying it should have been closed because they had 18 months to. I'm talking about in the second summary judgment. So.
I understand, but you're saying that when you agreed discovery should be closed, that you're saying the judge misinterpreted what you were saying, that you felt there should be more discovery. You're saying it should have been completed.
Right. I did not say complete. I said it should be closed.
I understand.
She was the one who said it was complete. Yes.
And your other point is the judge never really answered the question that this court sent back, and that was in relation to the notary, that the the notary had said a certain person appeared before him on a certain date with the signature, but that notary attestation did not match the assignment document.
That's correct.
And that question was never resolved by the judge.
That's correct.
In your view, is that right?
Right,
Okay.
never resolved, right, yes, absolutely. If you want to go ahead with the appeal, argument for the appeal, assuming that, the motion to dismiss is, put aside for now, again, I go back to, going back to the two issues that the first appeals panel remanded this back to. One was the invalid assignment of the mortgage, and this appeal, the lower court judge claims that the appeals court limited its reasoning to the issue of whether the mortgage assignment was made in 2011. They did flag that. It was obviously, false information submitted to get around the issue of these assignments, the problem, the burden that they had with the assignments, but that was hardly the only issue or the only part of the issue that the first appeals panel vacated the judgment. I've addressed the argument that they now raise about these so-called mortgage assignments were done by an operation of law. I don't believe it has any merit. I've addressed it pretty substantially in my brief. I would go on to say, though, the only support they have for that argument is to cite an unpublished housing court decision that was made a year before the appeals panel decided this case. So it was already before that prior appeals panel, and it was not persuasive to them. Further, they brought up this agreement claiming that it was an operation of law in 2008 between the FDIC and Chase. But as I pointed out, that agreement between the FDIC and Chase was made on September 25th, 2008. It had a 6-year sunset. So on September 25th, 2014, it expired, and all of these so-called mortgage assignments were made after that date. Furthermore, again, the recording that we're talking about, the FDIC to Chase, which was done without anyone with authority to do it, it still required, and it was required under mass law to be recorded, a mortgage assignment. So I would say even disregarding that error for a second, that recording was made in 2015, the one without the authority. But the purported assignment to Bayview, which was their predecessor, this bank's predecessor in title in the mortgage assignments, that was made in 2014. So the Chase then was not the assignee of record when this assignment was purportedly made. On the issue of the note, I've also addressed that the plaintiffs have never provided proof that they held the original note. That was the conclusion and ruling of this very judge in her interim order. She stated that the issue was just dissolved, which we just talked about, because discovery was closed. That's not the case. Discovery should have been closed, but it was not complete. And again, she went on from making the statement that discovery was closed and they have not resolved the two issues sent down on remand from the appeals court. And then she she completely reversed herself in the final judgment. And in that, if you read the reasoning in that judgment, it just makes no sense. I mean, she basically constructs a kind of a straw man fallacy that was never made. She cites a new affidavit that they produced in 2023 from another clerk, incidentally after discovery was closed, as a support of making this final judgment, and that affidavit it brings absolutely nothing new to the case. It's simply a complete copy of the affidavit made 6 years earlier that has been discredited. And indeed, the only thing that new affidavit did was reference the affidavit from 6 years ago and saying that's good enough for me, and I'll check a box off that says that we did hold the note. So again, I don't think I think what the judge claims for support is simply not there, and I don't think there was anything new brought to the case to resolve the very basic issues that were sent down by the first appeals panel.
I don't see any other questions for you, so we will take the rest of the arguments on your papers.
Okay, thank you.
Thank you. And just don't leave. Just have a seat at the table while opposing counsel makes his argument. And as you approach, did you get a copy of the motion to dismiss?
I did, Your Honor.
Okay. I've requested it from the clerk's office, so we'll resolve that.
May it please the court, Jason McKean for U.S. Bank. Your Honors, as Mr. Perry has pointed out, this matters are remanded to the trial court on two issues. The first was a matter of discovery, and there's no question that at that November 11th hearing, Mr. Perry indicated that discovery was closed. I'm sympathetic to the fact that he is a pro se defendant, but this matter has been up and down, litigated every 6 ways from Sunday. It's not convincing to me that he didn't understand when the court explained to him what the closing of discovery meant,
Well, he says closed but not concluded. Right? So hypothetically, I could send out a request for documents under Rule 34 within the deadline, but it hasn't been responded to yet. It doesn't preclude me from filing a motion to compel if the other side doesn't comply, does it?
It doesn't, but no motion to compel was filed.
I'm just trying to figure out what the difference between conclude and closed is.
I don't think operatively there is a difference. He had filed in the past multiple motions to compel. One was not before the court at that time. He indicated it was closed and he wished to move forward with the arguments at summary judgment. The second point is the FDIC's, the matter of whether or not that transfer from the FDIC as trustee for WAMU to Chase was valid as a matter of law. It has been tested against Massachusetts law by more than the trial courts, by more than the housing court. The statute is clear that free of any approvement or consent, the FDIC, by the nature of its existence, is enabled to transfer these distressed mortgages to other banks and other parties. The U.S. District Court in Cullen applied it to this very fact pattern. This was a FDIC to U.S. Bank, same trust number, same everything. They found that the federal law obliviates the need for a specific written assignment as required by the state. And it's that opinion that the trial court, the housing court, took in that footnote and embraced further. So it's our position that the FDIC's power to has been able by federal law to transfer mortgages without an assignment has already been tested by Massachusetts law. The district court found it to pass that test, and the housing court has found it.
Let me ask you about that, because I'm struck by your brief that, as the name implies, it was brief, and I noticed in the, you didn't cite any Massachusetts appellate decisions, nothing from this court, nothing from the Supreme Judicial Court. Is there no authority from this state that has any bearing on this case?
In my search of the record, there was nothing that addressed this FDIC issue in the appellate or the SJC.
Now, let me ask you about the questions that this court had when it sent this matter back. Did you ever produce, or did your client ever produce, the notary attestation that went with the February 13th, 2015 assignment? Because that still seems to be an open question. The question was asked by this court when this case was first here, and I'm looking through the record here, and I don't see that that question was ever answered.
It's that question is our position is mooted by the fact that you can have
Okay, right, I got you. All right, so you're saying that the question did not have to be answered because the FDIC, as receiver, as a matter of law, assigned this mortgage when the bank failed. So you didn't even need an assignment to be recorded.
That's correct.
Okay, but the question really was not answered, though. In other words, your client never produced the attestation that went with the assignment that's on record.
They did not provide anything further than was produced in that discovery.
So he's
What you said, I didn't hear.
But we didn't produce anything further beyond what was produced in discovery. That attestation was not provided.
So Mr. Perry is correct then in what he's saying, that one, the question was not directly answered. The question that this court had was not directly answered because the attestation was never produced. And two, in a related question, discovery really was never completed because that document was never produced.
Maintain that his position that closed is completed, the desire to move forward at summary judgment indicates an acceptance of the discovery as it stands. And again, we would say that while that attestation was not provided, the federal law, the powers of the FDIC under federal law as applied to Massachusetts would moot the need for that.
So, can I just say, it's hard to feel bad for your client in the sense that right from the very get-go, there was this, the housing court justice called it a Scrivener's error, but this just document that never existed that you put in an affidavit that says in 2011 this assignment happened, which is wrong. It's not like, oh, it was the exact same date in month, but the wrong year. It's just completely wrong. And my only thought is that somebody didn't do a very good job in a cut and paste, and they put it in an affidavit to show that this is an assignment, and it caused a question on appeal. Because absolutely, hard hill to climb, but Mr. Perry is entitled to show, to be able to, as a defense, say that the chain of title was somehow broken. And so that called into question. And then the issue of the 2014, 2015, and different notaries. In the very argument that was available on the first motion for summary judgment, which you're now claiming victory, was there, that in 2008, that when the FDIC took over Washington Mutual, that this transfer happened as a matter of law and that no assignment needed to occur, that anything in 2015 or whether it was 2014 was confirmatory in nature, end of story, was all sitting right at your feet, and the argument to be made at the first go-around. And so when faced with an appellate court decision that obviously you don't like because it sent it back for further findings, you go to a different theory of why you win. This one's a little bit, I mean, is that right?
That's right. Unfortunately, I was not with the firm at the time of that first appeal.
I'm not blaming you personally, but, right?
I understand that my client is not necessarily the most sympathetic of corporations either, but I don't think that necessarily affects that operation of law that puts the assignment into J.P. Morgan Chase.
But understanding that an individual, and especially a pro se individual, comes before the court and says, I'm challenging the chain of assignments. I want this document. I want to make sure it lines up with the right date and the right signature, because I think that there's something amiss here. And I don't think you, U.S. Bank, have legal title, proper legal title to, what used to be my home, and what I still believe is my home. At the end, instead of providing the documentation that was requested and that the court said, we need some clarity on, and then saying, even if that February 13th, 2015 assignment had the notary issue, whatever, we gave it to Mr. Perry, but the argument still doesn't matter. Why wouldn't you just give it?
Your Honor, it's with my clients provided everything in discovery that they had available to them. It's whether or not the Scribner's error.
No. Do you have the February 13th, 2015 document that you did not provide? Right? That's the JP Chase to Bayview.
That was provided. The assignment from JP Chase to Bayview was provided with the initial complaint. Like we did not submit discovery at all.
Right, but you didn't have the notary attestation.
We did not have the notary
attached to it.
attestation.
So that's why this court questioned it originally, that how do we know this is a genuine document?
That's correct.
Right, and that question has still not been resolved. Except, I understand your argument, you're saying it's resolved as a matter of law, but the fact of the matter is, this individual has been put through a lot here because U.S. Bank didn't produce that document, has never produced that document. Correct? Am I correct in that?
That's correct.
Well, let me just ask if you don't, because the reason I asked about mass cases is because this stood out to me, because your client, U.S. Bank and Trust, maybe this is a different U.S. Bank, but we have a case, U.S. Bank National Association, may or may not be connected, I don't know. But in any event, it's versus Ibanez, a 2011 case from the Supreme Judicial Court. And I think this is where Mr. Perry is going, because the case says this: one who sells under a power of sale must follow strictly its terms. If he fails to do so, there is no valid execution of the power, and the sale is wholly void. And that's citing an old case, a 1905 case from Massachusetts. So Massachusetts does have some case law on this point, and the reason I raise it is because I'm trying to put myself in Mr. Perry's position. You run into some difficulty, your lender is foreclosing, you know your lender is Washington Mutual Bank, but you receive a notice from U.S. Bank Trust saying, pay up or we're going to foreclose, and then you get the notice published in the newspaper that says it gives all this history. Washington Mutual Bank had the mortgage, and then it went to J.P. Morgan. There's no mention of the Federal Deposit Insurance Corporation in there. There's no mention of the fact that there was a bank failure. So your average borrower who's in this position and receives this documentation, how do they know that this is legitimate, that that I owe this organization the money? Now, I think that's what that SJC case was trying to highlight for everybody, that it's very important for lenders to cross all the T's and dot all the I's in dealing with people so that they understand what's going on.
And I entirely agree with that position, Your Honor. The complaint, again, has the acceleration notices with that gives the borrower the opportunity to contest, the opportunity to contact if there's anything wrong with that. It has the default letters. All these things are sent prior to the foreclosure action, all of which comply with Massachusetts state law, with Ibanez. There is ample opportunity for you to look at this acceleration letter and call the phone number that's bolded across the top and be like, can you explain where this came from?
But Ibanez changed the whole landscape of this litigation, right, for people in Mr. Perry's shoes, in terms of what the bank's obligations were, right?
That's correct.
The litigation, this was a tsunami of litigation following Ibanez. I'm struggling with yes, Ibana's is the law in Massachusetts, but you're telling me that because the bank failed and the FDIC stood in, that the Ibana's requirements are mooted?
That it's mooted insofar as an assignment is required from the FDIC to Chase. There was a confirmatory assignment with that Scrivener's error on it. There was a path and title, Scrivener's error notwithstanding, but as it stands, the FDIC is unable to transfer that mortgage without an assignment.
Okay.
If there's something further, I would rest in my brief.
Let me just check. Okay, it appears that there are no further questions. I have received the motion to dismiss. I've distributed it to the panel. If we have anything else that we need in writing from you on the motion to dismiss, we'll enter a court order in that regard. But if you don't hear from us, assume we have what we need, okay? And I apologize for that. For some reason, it made it to the clerk's office, but not to the judges, so I apologize.
Thank you.
The matter is under advisement. Thank you both. The last case that we'll be hearing today is Gagne Realty Corp. versus BBG Souza Enterprises, Inc., docket number 23P1306. I believe we're going to hear from Mr. Dombrowski first. I was going to say good morning. It's now afternoon. Good afternoon.
Good afternoon. John Dombrowski on behalf of the defendant appellant BBG Souza Enterprises, Inc. This is a case that arises from a unit that's operated as a restaurant in a strip mall in Leominster, Massachusetts. There was an eviction action in the Superior Court. Had a 4 or 5 day trial, not consecutive days. Decision was rendered and my client appealed. I think it's important to note from the outset that the trial judge, in rendering her decision, ruled that the combination of the breaches was what considered a material default, was a combination, not one in particular.
But not the grease traps, right?
Not the grease traps, correct, Your Honor. So taking the first issue up, the factual background is my client was storing items in a storage pod, which was a big unit, at other property owned by Mr. Gagne, located, depending on a short distance from the property in question. And the lease defines a default as being, failure to perform under the lease itself, but then it had an added proviso, failing to perform any or under any other agreement between lessor and lessee relating to the premises. The trial court found that the use of this iPod and my client's failure to move it when asked was something that related to the premises. From our perspective, when you look at the lease itself, the language of the lease, the term premises is defined in the lease as being strictly that unit in the common areas associated with the strip mall. There's no mention of any other properties. And this is a lease that was drafted and prepared solely by Gagne and his attorneys. In fact, if you look at the lease itself, the area where Mr. Souza's attorney, BBG's attorney, would be, there is no attorney because no attorney reviewed it. There's no, the notice would go to Gagny's attorney. There's no attorney listed for Mr. Souza. If you wanted to make that stretch, you could have put in the lease itself that it's relating to the lease. Any other agreement relating to the lease, or if the iPod happened to be in the parking lot of the premises. But in this particular case, to say that we've got this side deal over involving a property not referenced at all in the lease could result in a default under this written lease, we would say is entirely inconsistent with the terms of that lease. And I think another point that makes my client's position on this issue more compelling is the fact that there was an earlier lease. There was a 2015 lease. And Mr. Souza started using the iPod storage at the other property during the 2015 lease. When the 2020 lease came up, there were other things added to that 2020 lease, but there was no mention, not even addressed, of this iPod storage unit. So for those reasons, we would say, we would respectfully suggest to the court that on that particular issue, it was error of the court to tie those two together, particularly when the ramifications are so severe.
But there were so many material breaches. She said 3 out of 4
yes.
material breaches, and the combination of these material breaches. So if you took the storage trailer out, there's still the other material breaches relative to the buffet station and other items in the fire lane, the
Yes.
Portable heaters in the fire lane.
If I may, and again, and I admit I think that my brother did a better job of briefing this particular issue than I did as far as the law and analysis of the law is concerned. But the issue with respect to the outside storage, if you break it down very simply, is that an insignificant breach? Is it insignificant? Because there is a default clause, so that's the standard. Is it insignificant? And I'd refer you to page 178 of volume 1 of the record appendix, which is the only photo of this outside storage. And mind you, this is in the backdrop of COVID. The reason the salad buffet station and the need for heat lamps was because of COVID. The state mandated that tables be stored. Eating at a buffet suddenly wasn't very palatable. This is a small restaurant, 1,600 square feet of area. But if you look at that photograph, and you can see there's a pole in that photograph, and the reason for that pole is this unit has always been used as a restaurant. And so when you open that back door, the back door would latch onto the pole, so when it was hot in the kitchen, it would cool off the kitchen. You can see all those items are stored in the shadow of that door. This is not onerous. If you look at the cases where they talk about...
But even so, I mean, as the judge below said, you could be attracting rodents. There could be public safety hazards. I mean, just because they can see it from the door doesn't mean these hazards go away.
But these items were there for 2 years, 2.5 years, so at the time of the trial. There were no issue of rodents caused by pieces of equipment being stored in this small area. There were no issues of debris. There was not one complaint by another tenant or by a fire department official or by a dumpster. No evidence of that. And the reason being is it did not block the fire lane at all. It was a small amount of equipment neatly stored against the building. If you look at the cases, excuse me, if you look at the cases that talk about significant versus insignificant matters, DeBella, altering a structure, altering a shed without permission was considered insignificant. In Mactier, failing to procure insurance, that was considered insignificant. In the Judkins case, failing to paint the premises was considered insignificant. The Howard Johnson case, failing to submit your financial figures and failing to have them ultimately signed by a financial officer, all these were considered insignificant by the court. Here we're talking about...
But this fact finder found it was a material breach, right? That's the fact finder's job. Are you saying that that factual finding is clearly erroneous?
I'm saying it's clearly erroneous given the circumstances and given the examples we have to work with the case law. And I'd further...
How many cases like this that you found where, for example, the grills and I guess they're smokers are stored outside along a fence near the trash? Do we have any cases that talk about that?
There's no cases on point that I was able to find, Your Honor. I would also point out that in this particular case, we have the lease is signed. Several months later, there's an email, and I believe that's page 176 of Volume 1. There's an email sent from Mr. Gagne to Mr. Souza basically saying, hey, not even a demand, basically saying, it's more of an inquiry, like what's going on with that piece of kitchen equipment that's outside? And then there's some response by Mr. Souza. Then we don't hear about this particular issue. Not one correspondence email until the notice to terminate 11 months later. How important was it? Again, we're talking, does this justify forfeiture of a lease? There's evidence that Mr. Souza invested in the appellee certainly disagrees, but there's evidence that he invested $90,000 into this premises.
But you know, the overall impression I got from reading these emails was that Mr. Gagne was he seemed to be very kind and accommodating, and if anything, there may have been some forbearance on his part, but certainly not a waiver. It seemed that he was trying to give his tenant an opportunity to, straighten out the problems and so forth, and it just wasn't happening, and there seemed to be a little frustration. And like I said, to his credit, I mean, he treated him with the utmost courtesy and respect, and what else is a landlord to do in a situation like that? Because it can affect other tenants. This wasn't the only tenancy involved. There were 12 or so other units involved in the property.
I don't disagree about the temperament of Mr. Gagne, but I think there needs to be a factor of subjective concerns and objective concerns. And subjectively, the reasons advanced by the appellee are, well, it may cause problems with pests. I don't see how that's possible, but that was the reason that was advanced. The other reason advanced is it may cause debris to accumulate. And then it may cause safety issues. But the reality is, objectively, We had a trial period. This wasn't like a model or a pilot. We had a good 2-year trial period where there was no evidence of that. And the reason there was no evidence of that is objectively, when you look at it, during a pandemic, when the mandates, particularly on the restaurant business, were very difficult, there are a few pieces of equipment stored right outside the back door against the building. Is that, I guess the question for this panel is that insignificant or is that significant? Does that justify, regardless of someone's personality or mannerisms, does that justify forfeiture of a lease?
What do we do with the other photographs of the, the smokers kind of strewn about and the overflowing garbage and all that? Is that something we should be considering?
I mean, those are photos that were taken during the trial, while the trial was ongoing. I suggest to the court they're cherry-picked. They weren't brought up as grounds for the eviction. The issue of the charcoal grills, the issue of the dumpster, none of those issues were brought up as grounds for the eviction. And the case law that I've cited in my brief, Cummings and the Strichersky, you'd think with my last name I could pronounce that, but the Strichersky case, they talk about, this particular mechanism of evicting someone is a creature of statute, and you've got to follow it precisely. Those items were not part of the eviction process, and shouldn't be considered, should not have been considered by the
We
court.
may have to leave it there, but let me check to make sure if the panel has any additional questions. We will have to take the rest of your arguments on your brief. Thank you very much.
Thank you very much.
Mr. McGee.
Sorry, Tom.
Thank you, Your Honor. Good afternoon. May it please the court, my name is Timothy McGee. I represent Gagne Realty Corp., which is the landlord, was the plaintiff below, and is the appellee here today. I'll probably bounce around a bit because I think it's probably more critical for me to respond to some of the things that my brother has said and to highlight some issues that I think are more significant than he had given credit for.
Before you do that, I have one discrete question, which is, in the issue he's raised about the consideration of the tenant's actions after the notice of the termination of lease.
Yes.
Can we consider that on the question of the default and the potential to cure the default?
No, Your Honor.
Okay.
I agree that was not an issue raised with respect to the trial, with one exception. It actually came up after the trial in connection with a request for an injunction.
The emergency relief
Correct.
request.
Because of continuing violations of the same nature that had occurred during the trial, but prior to the trial, but on a more significant basis. So it's not related to the issue of eviction. But first, I'd like to address the storage trailer and the fact that as Judge Eurasius found, it was related to the premises. The first point is that my brother refers to the premises being described expressly in the lease as the physical layout of the property. That's not so. The premises is described in the lease as being a restaurant that's located in a particular area. The Judge Eurasius went on to find that the storage trailer agreement was related to the premises for some very specific reasons. She found that equipment was stored in the storage trailer, which was the size of an 18-wheeler truck, not a pod, but an 18-wheeler truck. Equipment was stored in there for the restaurant, for the Karma Kettle restaurant. equipment was stored there for the catering business conducted by BBG Sousa from the restaurant, that during the time of COVID distancing, that tables and chairs from the restaurant were stored in the storage trailer on a temporary basis. Again, restaurant equipment stored there on a temporary basis, which begs the question, if the tables and chairs could have been put there on a temporary basis, why could not the materials that were stored outside in the fire lane have been put there on a temporary basis also? And that the Judge Eurasius found that the trailer was also used to store equipment that was purchased by Comiquetto for later installation in the premises in the restaurant.
Sorry, could you say that last part again?
That he purchased, from time to time, the defendant, the tenant, would purchase equipment for later installation in the restaurant during a time that it was to be renovated. One item in particular was a Rodizio oven that he had purchased from some sort of event and stored it there for some time until the renovation was taking place. The renovation taking place gets us to the claim that $90,000 was spent on the renovation, and that it's apparently some sort of an equitable-based argument that BBG Sousa is making, saying that he shouldn't be deprived of possession because he had spent so much money investing. He had invested so much money in the renovation. There was no evidence whatsoever except for a bald assertion by Mr. Sousa that he spent $90,000. The only documentary evidence produced at trial on that issue were two documents. One was the estimate by the contractor, the Comiquetto contractor, an estimate for the total for services and goods, labor and goods, which was $9,000. The second was the building permit application filed on behalf of Comiquetto in connection with the work to be done, and that stated a similar cost of $9,000. Mr. Sousa did testify, but it was somewhat circuitous testimony that was focusing on things like tablecloths, plates, silverware, glasses, tables and chairs, all things that could be removed. So none of that, even if that had come anywhere near the $90,000, none of it is something that would have to be left behind. So that's a misplaced or misguided attempt to create some sort of an equitable argument.
So nothing structural? He didn't make structural improvements to the building?
The structural improvements were the $9,000 worth of work.
$9,000?
$9,000.
I just want to make sure I heard that correctly.
And that's in the record. There are two documents in the record that support that. We think that the judge's conclusion on the storage trailer agreement being one that's related to the premises is well-reasoned, and it's entitled to deference anyway, but even without giving Judge Eurasius deference, the subsidiary findings well support that. The defendant would have us think that the storage trailer agreement has to be viewed in a vacuum, that if the storage trailer had not been located on the premises, then it's not related to the premises. That's illogical. If we were to assume that would require one to conclude that the landlord would, for more than 5.5 years, allow someone unrelated to the premises to store an 18-wheeler trailer on nearby commercial rentable property with no additional rent and no obligations. That's strange credulity.
Was it okay with your client until the whole new tenant enterprise car was going to move in? Is that really what the impetus was?
Yes, that was the impetus, but that was an impetus based upon the express agreement of the parties. As the judge found, the agreement of the parties was that the trailer would be moved when the defendant was instructed to move it by the plaintiff. And the reason for that was obvious. He allowed it as an accommodation during the time that the property was vacant.
But they needed the parking area,
No,
the enterprise cars.
no, the enterprise lot, the lot where the storage trailer was located was a separate ground lease piece of property. So it was the entire area,
Oh, it was the-
not just
okay, I
a
apologize.
rental bay, not just a rental unit. And Mr. Gagné also testified unrebutted at trial that he would not have allowed that to be put there if the lease had not been in place. So it's strange credulity that there would have been such an agreement apart from the lease. If there had not been a lease of the premises, then no one would have been allowed to put this trailer there just, without any particular obligations. The outside storage issue, if I may briefly address that, again, the judge made very detailed, specific findings, and she's not only entitled to deference for having made the conclusion that that was a material breach, but her findings are so specific and her rationale is so detailed that it lends support to her determination. She specifically found that Mr. Gagné insisted on including the term in the lease prohibiting outside storage. He specifically insisted on including that because BBG had previously stored materials outside and he wanted that to stop. She also found that Mr. Gagné believed that outside storage would cause safety, aesthetic, traffic flow, and sanitary problems. And because of that, it's a reasonable inference from that that it was an essential item and it was an essential term of the lease. And Mr. Gagné also testified at trial unrebutted that he would not have entered into the lease without that term being in there. The judge then found that these various items were stored outside. Regardless of what my brother says, there was nothing in the record testifying that there were no rodent or no debris issues, nothing in the record whatsoever dealing with that.
But the judge did say that it was the combination, I believe, of the breaches or of the issues that constituted the material breach. Is it your view that each one standing alone was sufficient?
Correct. Yes. And I think that comes through from a reading of the judge's decision. And in terms of, we must keep in mind that the judge not only found that these were material breaches, but also because there was a default clause in the lease that these were breaches that were neither material nor accidental. The cases cited by BBG Sousa, the tenant, do not support its claim that these were insignificant. The cases that they cite dealing with insignificant circumstances actually bolster the claim of the landlord. The Judkins case, for example, all of these cases deal with one-off types of situations where there was either no or limited opportunity to cure, no or limited notice, and no or limited opportunity to cure. In the Judkins v. Charette case, deals with an accidental failure to pay rent on time. Again, a one-off situation where there was some dispute as to whether the rent obligation had been posted properly. There was some question as apparently the tenant had evidence that it was posted and the landlord had evidence that it was never received. Without resolving that issue, the landlord then went in and evicted. That's completely different from the current circumstances. Kaplan v. Flynn was a failure to paint, and the failure to paint was determined to be an insignificant violation. But the facts of that case were that the property had suffered severe wear and tear, that the painting of the property would have added nothing to the value of it or would have been a somewhat fruitless endeavor, and that the landlord used it as an excuse to terminate and gave no opportunity. The landlord went in without notice and filed an action to evict. Howard Johnson v. Madigan, That's a case where there was a failure by the tenant to submit gross sale figures in connection with a percentage rent clause in the lease. Again, that was a one-off situation. The tenant promptly cured the default, yet the landlord went through with the foreclosure anyway. These sorts of insignificant violations show what a low threshold it is for that to be a determination. Here, we had extensive notice. This has been quite an odyssey by the landlord for years, trying to get the tenant to comply with lease obligations, significant to the landlord lease obligations. He notice after notice, attempt to cure after attempt, or opportunity to cure after opportunity to cure, none was ever done. Then finally, the judge found that notices of the defaults began at least as early as November of 2020. Not until, and that they continued consistently. She found that there were numerous and repeated notices of the violations and opportunities to cure. It was not until 2022, that out of frustration in January of 2022, the landlord finally gave notice to the tenant of the defaults, said you've got 10 days to cure. No cure was forthcoming. The landlord then gave another accommodation, an additional 20 days to cure. There was no cure after that, so he had to terminate the lease as of February 16 of 2022. And as of February 16 of 2022, the storage trailer had not been moved, none of the outside storage items had been moved, and even the grease trap problem, which is not before the court, but is a significant matter, that had not been resolved. So this has been a lengthy series of violations by the tenant, who's given every opportunity in the world to cure, and he did not do so. And I respectfully submit that Judge Eurasius was correct in her rulings, and they should not be overturned. Thank you.
Thank you very much. That will conclude today's session of the Appeals Court. I would like to thank our staff, in particular our court officers, our law clerks, and our excellent timekeeper. We will stand in recess. Thank you.